Whoa, Adam, that was so quick. I haven't even clicked my video thing yet.
Can you please look up this site?
See if we can figure out something.
Hi. So I just want to say, first of all, that I double checked with Recovery Addict. And he's all good with me being live at the same time. I am going to put his stream. Where is he? Oh, Judge Simpson was live with landlord tenant. I'll need to get back to that. Where is this link? A blue shirt and giant headphones. Well, my giant headphones are dead because I was recording on my iPad and I forgot them on. But we need to wrap up this Florida trial because my video about it is going live tomorrow. And I didn't want it to be like, what's the word? I don't want spoilers. Also, my brain is so tired. I've been writing for like 4 or 5 hours. So if I don't have good words, it's because I be wording a lot. And I be wording science. And science is hard to word. Actually, it wasn't science. It was engineering. You never expect me to write about engineering, right? Because I probably shouldn't. No, I'm joking. Where are we? Just a million tabs open about YouTube not wanting me to get my bank. It's all good, Adam. You weren't here earlier, but everything's cleared up. Everything's chilled. It's all sorted. Nobody's upset. We're all good. Where is this thing? Did I do the thing I was supposed to do? I don't think I did. This is going to be an interesting stream because I'm also hungry. And also, hey, Steve. Every time there's jury discussions, I'm just like, there's a simpler way, guys. We found it. There's a simpler way. Also can't get the lighting right in this room since I moved things around. So do we warm up with a little bit of Judge Simpson and then go to the other one? Let's see how much longer is left. 1 hour. I feel like we warm up with Judge Simpson so that my brain can get where it needs to be and I can have some pizza because that is much needed. And Vaughn is the superstar of all superstars. And also I'm a bit, oh, there's no sound. I can feel I'm in an argumentative mood. So probably not a good time to take on Gen Xers and.
District Court for County of Washington is now back in session. The legislature to provide. You may proceed.
It's my job, though.
Okay.
I am super hangry, but I've been grumpy all
Court
day.
calls case of Arbor Woods versus Armstrong.
Yeah, look, Steve, I do appreciate your willingness to debate things without taking it personally, but like it gets difficult because what I want to say out loud that I just don't is reminiscing is fun for some people and really not fun for others. And like, I struggle when women do reminiscing about back in the day, because back in the day, I wouldn't even have been allowed to have a job. And back in the day, I'm not crying, by the way, my eyes are just freaking itchy. Back in the day, female lawyers were held in contempt for wearing pants. Like, it wasn't all sunshine and rainbows. And also lots of people went missing back in the day, and lots of murders happened back in the day. And because there wasn't DNA and that sort of thing, they couldn't be solved. So
Good afternoon, Your Honor. Rachel Dornbush, Palace Law, on behalf of the plaintiff.
Hello, happy Friday.
Yes, and to you. Your name?
Sarah Armstrong.
Okay. And where are we on this case?
Your Honor, I think we may have reached an agreement. It did have my client drop off to Ms. Armstrong a private settlement agreement, as well as a conditional dismissal that would resolve this matter. And pursuant to the settlement agreement that was presented to Ms. Armstrong for review and approval, a conditional dismissal would enter today, and the terms of that conditional dismissal indicates that there, aside from escrow funds, would be a remaining balance due and owing to the community of $484.60. That includes the water sewer that's due on July 1, which Ms. Armstrong has indicated that she could pay on or before July 8th. And then the conditional dismissal would be an agreement to release total escrow, which Ms. Armstrong dropped off payment for her July rent of $668. So I believe the total in escrow is $4,008.10, which would be released to plaintiff.
You have how much in escrow?
$4,008.10.
I don't know if that's what I have.
Yeah, doing that now.
Oh, you know what?
$4,007.10. I've got 4,008, but maybe I did my math wrong. That wouldn't shock me. Let me see here. I had emailed the civil division and they had gotten back to me with a number. Let me take a look and see.
$4,008.10.
Oh, okay, then we agree.
Okay. All right. And that's going to be released to the plaintiff.
Correct.
That's
And so
right.
long as Ms. Armstrong confirms that that is the agreement she wants to move forward with, then correct.
I've gotten what I mainly was concerned about resolved, which was my driveway. The sidewalk, I'll just worry about it later.
Okay. All right. So as to the terms of the conditional order of dismissal, do you have any questions about that?
Nope, I'm in full agreement. I got what I asked for on that.
Okay. And how a copy was dropped off to Ms. Armstrong so that she'll sign it and then,
So Ms. Armstrong, I know I had mentioned, oh, do you have it with you? I wasn't sure if you'd brought it or not. Your Honor, I have not executed that copy. What I'm happy to do is to sign a copy on my end and submit it to the court. Maybe the court can just put the two signed copies together for a full.
that's fine. We can do that.
And then Ms. Armstrong, with respect to that settlement agreement, if you want to drop off a copy in the Dropbox if you prefer, or to somebody at the management office, or you can take a picture of it and send it to me, whichever is easiest for you.
It's just the last page, right?
Yeah.
What I need to sign?
Yep, and management will then sign and get you a fully executed copy.
Okay.
can we have a little
Bye.
laughing
Okay.
or something?
Yes. No, that's your only copy?
Yes.
Okay, so let's take all of hers, and if we can just make a copy, I'll keep her original signature. That way she'll have a copy of what she signed.
Do you need this as well?
What is that?
Adam, if you are in StreamYard, at the bottom, next to present, is settings. You have to go into camera, and then you have to, so that's mirrored. You have to make sure that you change it, and then the audio double check as well. But that's essentially, you can do that during the stream, but I don't know if you can do it as a guest, because also mine was logged in as like my normal StreamYard. I can't figure out how to make myself look less ghosty. Let's see. You can't share your StreamYard page. Man. I was just going to share StreamYard. It's like the picture is here. And then below, you've got the little squares that have like all the settings and whatnot. And below that is mute, stop cam, settings, present, invite, and leave studio. It's in those settings. But also if you set it up on OBS or whatever, then you're gonna have a fun time. Present. Hey Angie. We're just watching some Judge Simpson to let our brains decompress. And then we're gonna go over to the trial.
The court form that shows the amounts for the water.
No, 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 I'm
Okay.
good. I'm good. Thank you.
It just
Okay.
makes things so much easier, don't it, when people do what they supposed to do on their end?
If that would happen, I wouldn't have a job. All right.
I left out of here last Friday just laughing. I said, oh Lord, I know when he start doing this.
What? When I
Judge, that must be your tell. I hope you don't play poker. You may have just given it away on YouTube.
people keep thinking they know what I'm thinking.
Look, when you get to this,
Oh, when I
the frustration has already set in. Like, are you not listening,
Miss
people?
Armstrong, I'm never frustrated.
It's
I
true.
spend my life amazed, but not frustrated.
Maybe that's a good word for it. Amazed instead of
Amazed,
frustrated.
yes.
Flip it around. Thank y'all so much.
I will mark this conditionally dismissed. Miss Armstrong, you have a great week.
Thank you.
You should. You should, Adam. Were you on
Court
phone
calls
though?
Arbor Woods versus Crystal Thompson. Miss Thompson is not here. Would you like to proceed? Well, there was a judge taken.
Oh, I don't think, maybe I didn't know about this one, maybe. Oh, it's a continued motion to set aside. She appeared, she was supposed to pay the balance yesterday, and I'm looking at her ledger, Your Honor, I do not see. Judge, this ledger was from 6/26. If you want to pass on it a moment.
I will. I'll pass it.
Just double check and make sure that something didn't get dropped off yesterday.
Okay, great. All right. I'll pass that case. Court does call the case of Arbor Woods versus Felicia Hugan and Reginald Hugan.
Don't have them checked in.
They are not checked in.
May I be sworn, Your Honor?
Yes, you may. Do you solemnly swear or affirm testimony you're about to give will be the truth, whole truth, nothing but the truth, so help you God?
I do. For the record, Rachel Dornbush, appellate law on behalf of the plaintiff. Your Honor, there is rent to retain of $2,419.59, costs of $240 for a total due of $2,659.59. And we'd ask for a default possession only judgment with writ to issue after 10 days.
Judgment to the plaintiff, that is by default for possession, redemption amount, any amount requested, writ issue, 10 days. Court does call the case of Arbor Woods versus Alicia Oliver.
I think that one's, is it Scio Farms, Judge?
Yes, Scio Farms, I'm sorry. Sorry, I'm calling the wrong case.
Thank you. I needed that laugh.
Good afternoon. What's your name?
It's Alicia Clark, but
That's right. I actually did mark it. It's Clark, but I called it from the outside of the file. All right. She had done an SER, and I think you were going to pay 1,600,
today I
or
was
I mean 600.
1,000.
I had 1,000 judge and she actually dropped off 1,800. So
Yes.
the balance currently is $3,020.61.
Give that to me again. 3,000.
$20.61.
Okay, and she dropped. Yeah, I was looking at the wrong sticker from the wrong day. Okay, she dropped off 1,000. Okay,
1,800.
Oh, 1,800 judge.
1,800. Whoa, so you paid more than you said you were going to pay. Seriously?
Yeah,
I don't get that much.
that balance increased by $40 though. I don't know if you knew that, Rachel. Ms.
I'm
Dornbush.
looking at the ledger here and yeah, so from last week, there was just additional late fee that came due on the account. So
No, she's $10 for each
And-
money order.
and the $10
Oh.
check. Let me look. Let's see here.
Charge for money order. And
10.65, might I say. I'm just saying.
no, I hear you. All right.
Sorry, Judge. They emailed me the ledger. I didn't get a chance to print it, so I'm just grabbing it.
And just so
I
that,
see.
what's your monthly rent? Is it 1937?
1924.
Okay, gotcha.
Oh, yeah, I mean, there is, the fees from the money order. I don't see an additional late fee, but 4810, 4810. That's gotta be what it is, Judge, because there was multiple money order payments, so I see that's probably the reason why.
Okay, so, and then what's gonna happen is we're gonna get 1924 clicking in on the first.
Mhm.
Okay, all right.
Judge, just so you know, I've actually got the July charges on here. So the total as of July 1 will be $5,065.93.
5,000, give me that, 5,093
$65.93.
Okay,
Me now?
yes,
Okay. So I had to redo the SCR because the rent, technically speaking, the water is separate from rent,
got it.
technically speaking, but it's all in the same ledger, and my caseworker is very technical. I did speak to Rhea with Washtenaw Mental Health Services. She's my children's caseworker, and she sent a text message yesterday saying if Laney Thrift Shop is going to pay $200. I did email or text her this morning asking her if she could send an email because the office also asked for that.
Okay,
And I had an appointment with Faith in Action at 9:30 this morning, and she actually asked, what's the property manager's name?
Amy, you may have talked to Amy,
Amy.
that's the new property manager, or Jen or Jeanette.
Yep, Amy. She asked her, I got the email, to forward her the ledger as of today's date. But Amy said she would need a written copy, so I guess I have to stop in the office after court because I didn't have time to do it before.
oh, Amy needs a written copy of the request.
Yes.
Got it,
Because Faith in
Okay.
Action said they would potentially pay the difference from the 200 that you, Ypsilanti Thrift Shop was sending, but that's minus the $40. That didn't include the 40 that was added for the money orders.
got it, okay.
So the 3,000, is it 3,020?
3,020.61.
So if you minus the $40, whatever that balance was, 200 was coming from Ypsilanti Thrift, and then Faith in Action wanted that difference so they would know what they would pay.
Okay, so looks like
Got it.
208061 was the amount probably taken into consideration, 200 from Ypsilanti Thrift, and then I can't do math, 2680 from Faith in Action.
Yes.
or
Now, did they,
20.
ask this, have they committed to pay the balance or?
Not yet, because I left there and came straight here. And Amy said she needs the request in writing to release the documents to them.
Okay, all right, gotcha. Okay, and then there's the SER that's out there.
Yes.
Okay. So,
And Latanya Fair from Friends Indeed. She was waiting on updated information because she said they would potentially pay 800.
so there's also possibly 800 coming from Friends Indeed.
Yes.
Between all of those, Judge, Miss Clark may have a good portion towards her July charges then, which will
Absolutely.
help get her ahead.
It almost looks like, well, what would happen is maybe about 1,000 off, somewhere around there. If I'm doing this, because basically with the 200 and if the thrift shop Faith in Action come through, that's gonna cover you through June.
Yeah, and then with the SER, Judge, I think Miss Clark's household is either 6 or 7, including herself, and so the SER should be pretty sizable.
Right, if FCR comes through, which if it's 6, it's 1,040.
Between
If the
those two,
SER comes through, and
real
then
close to
Friends
covering
Indeed,
July.
if they come through, yeah, you're gonna be almost right on track and covered for July.
What
That's
is
a
Mercedes doing?
What?
That's a positive.
Yes.
Okay, well, let's see, okay, so we've got those sort of out there cooking,
Yeah.
all right? Is there anything that you can pay between now, my next date, I don't have the 5th, I'm actually gonna try to take a day off. So on the 12th, between now and the 12th, is there something that you can pay? I'm willing to give you a shot because every time you told me you're gonna pay, you've done it, so.
I can do 1,000. I might not have to give that much, but
Pardon?
I said I can do 1,000. I might not have to give that much if everybody else comes through by that point.
Right,
But yes, my mom said she's going to make sure because we cannot move back in with her.
okay, all right. Okay, let's do this then, okay? You think there's 1,000 that can be paid?
Oh, most definitely.
All right, so pay, because these other groups are gonna pay, and they're gonna pay it based upon what the ledger is,
Yes.
okay? So the $1,000, I want you to pay into court escrow,
Okay.
okay?
By the
So-
12th,
Well,
or as soon as possible.
how soon can you do it? You tell me.
I can do it by, is the court open on Friday of next week?
Yes, we are,
I can do it by the 5th.
by the 5th.
Mhm.
Okay, so by the 5th, $1,000 in the court escrow, that has to be in cash. So you're not gonna get the $10 charge, you're not gonna get.
Okay.
Okay, nor the 65 cents for the money order. Okay, so I'm saving you.
Yeah, I mean, she's get charged $10 for dropping off a check today too, so. It's just what happens. I know,
Okay, all right.
because the online, and I asked when I went in today, I said, is there a way for me to avoid the extra charge because I'm trying to get the balance down? And they said, unfortunately not. The whole balance has to be paid before I can resume paying back online.
Get yourself back. Okay, all right. So let's do this. Put the 1,000 in cash into escrow here.
Okay,
Okay, then everybody's working with those numbers. We'll hold that.
okay,
And then that way we can figure it out and where your balance is and everything and figure out what we're gonna do with that.
okay,
Maybe part of that, after everybody pays, even can start partially paying your August,
right. Okay,
right? So we can get you back on track. How's that sound?
it sounds great to me.
Okay,
I'll be able to go to sleep tonight.
all right. And I know it has got to be worrying you.
Just a little, because my mother and father said, there's no way 6 of us are coming back to her house.
Got it. Okay, so let me, with all of that in mind, then July 12th at 2 p.m.
Okay,
Okay, so get the 1,000 in, we'll figure out what these folks are doing, and then hopefully we can, well, I think we will. We'll get through this.
we will. So 1,000
Okay.
by the 5th, yes, and I just write out there at the windows.
At the window, you can do that. And Ms. Clark,
Yes,
I'm just gonna say this to you. When people are behind it, they're behind this much, it can be exceedingly stressful and people can have all kinds of different reactions. And I'm just gonna tell you, it has, as you come in here, just your fortitude and your staying positive is a joy to me.
thank you.
Okay?
Mhm.
All right. You take care and have a
You
good
too.
weekend.
Have a good day.
I don't know. I cannot work out this light. Like, if I sit far enough back, I don't know. I have a feeling it's my screen, but I don't know what to do about that. So, because, yeah. Anyway, back to court. Little distraction. Oh, you
And
can't
is
see.
that, she had one that she passed and
Oh,
were you ready on that one, Ms. Dornbush, or no?
Not quite yet, Judge. I sent my client a text, but I don't think I got a response. So let me
Okay,
off my camera, mute myself, and I'll be right back.
okay, and then, oh, and Ms. Luckoff has shown up, so perfect time. Arbor One West versus Mercedes Houston.
Good afternoon, Your Honor. For the record, Cheryl Luckoff on behalf of the plaintiff.
Ms. Houston,
Can you hear me?
Ms. Houston, are you
Hello?
there?
Can you hear me? Hello?
Hello?
Can you hear me?
Yes, I can hear you.
Okay, so I don't even know if I'm allowed to do this. Miss Houston is actually a very good friend of mine. So
She's what?
she had some personal matters going on, and she just asked me if I could join the Zoom meeting to let you know that I will be removing her things from her apartment for her.
That you will be?
Yes.
Okay, and when is that gonna happen?
So I have a trailer and a truck and everything. I actually live in Jackson County, but I plan to do it on this Sunday. But I was just going to see if I could possibly have maybe a week. I'm not gonna push it to the very end. I would just in case something were to come up hypothetically, on Sunday and I
Okay.
wasn't able to make it, I would say Monday or Tuesday at the very latest, but I plan to do it this Sunday.
Okay, so here's what I'm gonna do. I'm
Okay.
going to, and you can let Ms. Houston know this because she's not here. I'm gonna grant the plaintiff.
Okay, just a heads up. YouTube is rejecting every single comment of mine as spam. Like, what the heck?
For judgment.
Okay.
There will then be a writ date, and so she will have to have everything out by that time. We knew that this is really what we're looking to do, is to get her stuff out, and it was just
Yes.
giving her time to be able to arrange that. Sounds like
Okay.
she has. So, okay,
Okay, so what day can I let her know, like, as the deadline?
okay, hold on one moment.
Okay.
Look up in before. I have not. Ms. Luckoff, can you raise your right? You solemnly swear firm testimony you're about to give will be truth, whole truth, and nothing but the true self you got.
I do. Your
All
Honor,
right,
plaintiff
go
moves
ahead.
for entry of a default judgment, rent to retain $2,196. Court costs $175.10 for a total redemption figure of $2,371.10. Writ to issue on or after July 8th, 2024.
Okay, so, and court judgment to the plaintiff, that is by default for possession, redemption amount, any amount requested with the writ issue in 10 days. Okay, ma'am,
Yes.
if you could get everything out and the keys turned in by the 5th, that would be great.
Okay. Okay, perfect.
Okay.
I can do that, sir.
Okay, fantastic.
Okay, thank you so much. Yes.
All right, thank you. And if you talk to Miss Houston, give her our best and that we're praying for her success.
I sure will. Thank you so much, sir.
All right, take
All
care.
right, bye-bye.
Did I do it?
Arbor One West versus Destiny Boyd.
Cheryl Luckoff on behalf of the plaintiff.
She's here.
Yes.
No, there she is. Miss Boyd?
Yes, I'm here.
Okay, you're here. Let's see, where are we on this?
So, Your Honor, the defendant indicated she paid $630 on 6/20. It looks like our record show was paid on 6/24, but nevertheless, it was paid. So we're left with a balance right now, including the court cost of $610.10.
$610.10.
And
Okay,
today I went and paid I paid $580. I have my my money order receipts right here.
so you paid $580?
Yeah. This is one for 480 and then this is one for 40.
Got it. Okay, so you paid,
I meant
so
520,
right
I'm sorry.
now,
520.
I was gonna say that.
I'm
math didn't
sorry?
work.
I meant 520, I'm sorry.
you paid $520. Okay,
Yeah.
okay, so there's what, about $89 or $90 difference?
$90.10.
Okay, so,
Assuming that my client has received it.
correct. So Ms. Boyd, did that
Yeah.
get to the apartment, to the complex?
Yes, I went and paid that this morning. So
Okay,
the balance is $90.10.
right. So
Okay,
when do you think you'd have that?
I could pay all of that by the 5th for going
Okay,
to put that into my July
Here's
rent.
what I'm gonna, all right, here's what I'm gonna do, Ms. Boyd. Since you said you paid that amount, I'm gonna grant the plaintiff a judgment. Now, the reason I do that is that it would freeze the number for the month of June, okay? Because otherwise, if I
It'll
turn
keep
this
adding
out,
on.
right, they're gonna add on July,
Okay.
okay? But then you can get that paid and then start chipping away and working on July, if I do
Okay.
it this way, okay? Make sense?
Okay. Yes.
All right,
Thank you so much.
so, pardon?
Thank you.
You're welcome, Ms. Boyd. So Ms. Luckoff has already stated it, so I will grant a judgment to the plaintiff for possession. Finding no tribal issue after hearing for a total amount of $610.10 with a written 10 days. So but you're gonna get that paid before then, so you'll be good, okay?
Okay.
Okay?
So
All
just
right,
take the whole next month's rent plus the $9 and then just pay that off to the rental office.
right. The important
Okay.
thing for you is you have to make sure to get that $90 in by the,
Adam, don't know if we can
Yes.
hear you.
What?
Oh, yeah, we can hear you now.
Okay.
I don't know how to change the background though. Evie, I had my hand up because if I put this little light above my head, it fixes the thing. But like, I don't know how do I stay like this? This is not actually going to work. Yeah. Adam, you wanted to show us your fig.
Yes. Which actually my fig is a little wilted right now.
I seriously love the innuendo, first of all. Second of all, I hate fiddle leaf figs. If people ask me which plants to get to start off with, fiddle leaf fig will never. Oh, but that's like a fig.
Yes, it's a proper fig. It's a Chicago fig. And it'll produce figs, and I think there's some starting right there.
Figs are so underrated as fruit.
I think that's a weed whacker. But all right, I just wanted to to
what whacker?
a weed whacker.
Jeez.
What? What?
Only for that.
All right. I won't ask any questions, but there's lots of noise going on right now, and so I'm gonna get going. But thank you.
Cool.
Oh, what is it? What is the cute fig? It's a. I'm just. I'm imagining. I'm imagining the that one emoji's in chat right now, or if not, it will be.
That one.
I should
See, even my hand is too ghosty.
Yes, yeah. I should propagate it. I don't know, it's about 3 feet tall, but I should propagate it because these should be able to sprout their own trees, but I just haven't gotten to it. Here's the tag. I don't know if it has an age on it. Anyway, yeah. So, all right. How do I leave? I feel I'm a hostage. Okay.
So I think there we go. So this is the best I got with the lighting, which now looks bad again. Maybe if I just sit really far back, but now my pizza's over there. And I don't like being away from my pizza. Brandy, this is why I didn't want to add people on there, because I didn't want to be like, hey, I want to show this trial, and then we have people, but Adam had to show the fig. Had to happen. Also, if you want to be on RA, please do. The thing is pinned. It looks like they're still going. Jules is on still. I can't read the rest because I'm too far away. And I still look like a ghost. Once I turn my camera off, I'll ask Vaughn to help, because he knows this stuff and I don't. I'm pretty sure it's my screen. Okay, we need to move over to the trials soon.
By the 5th. But if you're going to have that in your July run-in, then you're going to be good, Miss Boyd.
Okay, thank you.
Thank you. You have a great weekend and holiday, okay?
You too.
All right.
He is, Steve, at the moment. He's been in vlogs.
Arbor 1 versus Dominique Jones.
It's a Friday.
Cheryl, walk us on behalf of the plaintiff.
Dominique Jones here.
Okay, you're here. Okay. And where are we on this case?
Your Honor, my notes reflect the defendant indicated on the 21st that she was going to pay this by today, I
The
believe.
28th.
We do not have a payment right now.
Oh no, I made a payment. I have my receipt. I can turn on my camera and show you. I did make a payment. I made the $500 payment. I was trying to pay it by today. However, my account is 2 things that I have that I need to see how I can fix. One, my account is nothing y'all can do about that. It was compromised. Somebody overseas tried to hack me. But okay, they said that they'll release that in I think they said 5 to 7 business days. That's fine. My thing is, I told you I applied for my SCR. My SCR was originally, she said that she would approve it. When she told me to bring in my paperwork for my the proof how you have.
Oh, we lost you, Miss Jones. Miss Jones? Oh, now she's. Miss Jones, are you there? She is not. I don't know what's happened. Did you try to? Oh, she dropped. Okay, well, I'll pass it. She's back.
Hello.
Hello, Miss Jones?
Oh my God, yeah. I was trying to find a signal. I run around in circles. Okay, don't laugh, please. Okay, so the problem was when I went to when I sent her it's called a complaint non-payment of rent, the summons that y'all mail to the house. Hello?
Yeah.
Oh my God. Yeah, when I sent her the summons that was mailed to the house, she said she had to deny me because the summons say my rent was paid through December 31st, which is not true.
Okay.
And And she said that she could not approve that because we say the last time I paid rent was in December. And it says it on the summons. It says I paid 206, which is not the right amount on here.
Okay, all right. I got you. And that's something they need to work on because that's really going to be a pro rata kind of calculation. So how much is owing at this point?
Your Honor, the total balance is, including court costs, $1,910.52. My notes indicate that on the first hearing, she said she'd pay $500 by the following Wednesday. That was not paid. Nothing has been paid since this court has started to hear this case.
I'm back.
There was a HAP payment made, but there's nothing been paid by the defendant for her portion of the rent.
Okay, if you still on my case, that's not true. Can you contact Arbor One? I took it in there today to $500. But what I was trying to say, I don't know what part I missed. My phone is going out. But what I was trying to say was, I can't hear you.
Hold on. My notes indicate that you were going to pay from the June 14th hearing, that you were going to pay $500 by the 21st. Did you pay that?
Remember when I came in court last time, I told you that I had it and I didn't pay it, but I paid it. Yes, I paid it. I can pull up my receipt or you can call the office. But
Your Honor, I think she's saying she paid it today. What she said.
Okay.
That's what I believe she's saying.
Can you hear me?
So, yeah, I can hear you.
Okay, so I was trying to tell you that my SDR, the lady said she was going to approve it. I have 5 people in my home, and she said that she would approve it. But the front of my summons, if you have it there, says December the 31st, and that I only pay $206 a month, and none of that is correct. Why she couldn't approve it?
Okay.
And the only reason why I didn't make the rest of it is because, like I said, my account was hacked or whatever, and they told me that I had to wait 5 to 7 business days. But that was from Wednesday, so that's almost over.
Okay. So there are a couple of ways of solving this.
Okay.
Because the first thing is, plaintiff has 1910, but if I have the 1910 and then let's say the $500 is there, I still have $1,410. That's owed.
Yes.
And then let's say you get that straightened out with SER, and if you've got 5 people in your home, that's going to give you a maximum of $870 that they would pay.
Yes.
Which would still leave about $540.52. Oh,
right. Exactly. I have frozen in her account. I can send it to Ms. Luckoff, my letter from the bank. If she want me to, I can actually forward it to her right now while we on the phone. From my other phone, I can forward the letter.
No. Okay, but here's what I'm going to do.
Only froze for a few days. So I can pay it. I just can't get to it until they unfreeze my account.
I understand. So I suggest that you might want to get that to Ms. Luckoff, but what I'm inclined to do at this point is grant plaintiff a judgment for their full amount. Now, here's the reason why I'm doing that. I'm on the last day of the month.
Okay.
If I go over, we're now then going to be dealing with July's rent.
Okay.
You follow me?
Yes.
So if you paid the 500, then it's 1410. If you get a judgment form that has the amount, you can take that back to SER, and that amount that you owe is going to be in there. Okay. And you can reapply. And then if you can get the 570, if that's the max that they'll pay, and your account gets unfrozen, and all of that can happen before July 8th, then this judgment would be paid off. You follow me? You got me?
Yeah, kind of. I kind of got you. You said I already put in the 5. So then you said if by the 8th, pay the rest of the 1410, but I can have the letter, the correct amount on the judgment to take to SCR. Is that what you said?
Yes, ma'am.
Okay.
Okay. Let me. Now that doesn't mean I don't know what the state will do, but at least then you'll have the correct amount, and then they can't quibble with you about when you paid it and everything along those lines.
Okay.
All right. So the court will find after hearing no tribal issue, I'll grant a judgment to the plaintiff, total amount of $19,1052 with the writ to issue in 10 days. So you got to get this all clear by the 8th.
Okay. So if it's clear by the 8th, then can I have at least to the 10th to pay the July rent?
Well, you can talk to them about that.
Or is that rolled in there? I guess I'm trying to ask,
on.
Is that rolled?
Ms. Jones, I'm not dealing with July rent because it's not due. I'm trying to get you through June.
Okay. Okay, so
I-
that was my question. Thank you.
Okay, but right. So here's what I'm thinking, but I'm not speaking for the landlord. I'm
Mhm.
thinking that if you get this clear, this amount, and now this amount, since I've issued the judgment's frozen, then if you get all of that cleared by the 8th, and they're gonna start a new case, but you paid everything by the 10th, I don't think they're gonna start a new case. Well, they can't, okay?
Okay,
You got it?
yes, thank you.
All right, good luck to you.
Thank you.
Thank you. Court calls the case of Arbor 1 versus Christy Davis.
Cheryl Luckoff on behalf of the plaintiff.
Ms. Davis?
I'm here. I'm here.
Okay. And we should have about 1,000 owing.
We do,
Right.
1,059.10, which I believe she said she was going to pay 500 today.
Okay, so
That's
yes,
what my notes say.
right. I have it, but I can't get into the office because it's going to be closed. So I got to get to the bank and get it. I have the
Okay.
500. I've been when I say I pay it, I'm going to pay it. I've been,
Okay.
you know.
Ms. Davis?
Yes, miss.
All
Yes,
right.
sir.
Now you're good. Okay, just hold on.
Okay.
You can't get it there till later today. At
Right,
some
and it's going to
point,
be right. It's going to be
Okay.
closed.
Okay.
Mhm.
Just listen. And then the balance of that amount, when would you have that?
In 2 weeks, I could pay it by the 5th.
By the 5th? The 5th is 1 week from today.
2 weeks. Then 2 weeks. I'm sorry. In 2 weeks.
By the 12th.
Yes,
Okay, and then how are you gonna take care of your July rent?
I will have it by then. I started my second job, so I'm paying them from week by week.
Got it. Okay. Here's what I'm gonna do then. I'm gonna do kind of the same thing that I just did with the last person, okay?
Mm-hmm.
Okay, I'm gonna find no tribal issue after hearing. I'm gonna issue a judgment for possession for a total amount due of $1,059.10. And a writ would issue on, I'm gonna extend yours out because of your payment. I'm gonna extend yours out to the 12th instead of the 8th. Okay, so that's gonna freeze that number. You gotta get that paid by the 12th, or they can issue a writ to have you evicted.
Okay, it would be paid off before the 12th. On my hardest.
Okay, I'm counting on you.
Oh, I appreciate it.
Okay, all right. You have a great weekend and holiday.
You too. Thank you very much.
Thank you.
Bye bye.
Bye-bye. Arbor 1 versus Regina Griffith.
Cheryl Luckoff on behalf of the plaintiff.
Regina Griffith? She is not checked in. Would you like to proceed?
Yes. Oh, you've already sworn me in. Your Honor, plaintiff moves for entry of a default judgment of possession only, rent to retain $2,213. Court costs $175.10 for a total redemption figure of $2,388.10. Statutory redemption period would apply.
Judgment to the plaintiff by default for possession, redemption amount in the amount requested, writ issue in 10 days. And then
Thank you.
I don't know that the tenant is present either. One's Foro, is it Masha Winge? They are not here. We have a Swahili interpreter. However, them not being here, would you like to proceed with the judgment?
I would, Your Honor. Plaintiff
Go
moves
ahead.
for entry. Thank you. Plaintiff moves for entry of a default judgment of possession only, rent to retain $2,356. Court costs $175.10 for a total redemption figure of $2,531.10. Writ to issue in 10 days.
Judgment to the plaintiff, that is by default for possession, redemption amount in the amount requested with a writ issue in 10 days. And our Swahili interpreter, sir, we appreciate you being here. We didn't need your services because they didn't show, but.
Thank you, Your Honor. May I leave?
All right, thank you. And you have a great weekend, sir.
Thank you.
Arbor 1 West versus Latasha Taylor. That matter is dismissed on plaintiff's motion without printers. Is that everything?
Thank you
for
very
Mr.
much. It is, Your
Thank
Honor.
you.
I apologize for being behind today. I hope it did not
No.
inconvenience you. I heard your comment, so she said I showed up. So I did show
right
up.
on time. Right on time. All
Well,
right,
thank you.
You
Have a good
great
holiday.
weekend. Yes, you too. Take care.
I'm glad you're taking a day off. You deserve it.
Well, thank you.
Take care. Bye.
All right. And Arbor Woods versus Crystal Thompson.
Hey, Judge, my apologies. I am still waiting on this, so.
Okay, that's fine.
After you passed this case, Ms. Thompson came into the courtroom, indicated that she was going to post escrow, and she has been down in the clerk's office since.
Miss Oh, okay, so
Oh.
she was gonna post escrow?
That's what she said to me from the gallery. I have confirmed she's in the clerk's office, but I don't see.
She was supposed to put, at her last year, she was supposed to put 2,000 in escrow. All right, tell you what. That would cover everything, wouldn't it?
Balance was just posted now.
Oh, so she put,
$760.
she put 760?
I
And I
think that's what was
have,
in escrow from the original motion that she filed, Judge.
right, that's her. Okay, she's here. So court does call the case of Arbor Woods versus Crystal Thompson. Come on out. State your name.
Hi, my name is Crystal Thompson.
Okay, so now what we have. I have 15, I have a total of 1519 for escrow. Restore motion.
Okay, so the judgment amount was for $1,832.37.
Correct.
That included May only. And so
Correct.
the issue, of course, is that at present, there is a total due of $2,851 and some change. The court costs are slightly off on here, and so there's $1.87 more in my balance. So in essence, 2851-ish is the balance.
Okay, so 2851. I have 15 what?
1519.
I have 1519.
And with July, Your Honor, which obviously is due
Right.
Monday, the total will be $3,616.29.
You said 16 or 60?
16.
16, okay. All right.
Okay, I think, wait, is my mic unmuted? Yes, it is. I think we're ready to head to the trial. So solving the light issue, I just turned on the light above me. However, if I land up wearing sunglasses on stream, you know, it's because it's like sensory overload from the sky. I missed so many messages. So before we go there, let me just go up. Where last did I say? Yeah, I was only like half listening to this because we were trying to figure out the light issue. And I was getting so confused. Did she actually pay it? Did she not pay it? Like, what is the situation? The more the day goes on, the more my bun just like loses its will to be a bun. Yeah, this was the best with the bidet. Ooh, in an hour, that's 9 o'clock. Yeah, that'll be fine. We'll make it work. Big fig leaves. All these mods are no moderation. Oh, so Brandy, I had a bit of a soliloquy this morning. Basically, what I kind of want is like at the end of the day, when I have no filter, I can just unmask and be me. And I want to be as weird as I am and whatever. So the only rules are really like, don't be offensive. So yeah. Greeners pops in every now and then, but haven't seen him today. She paid it today. Oh, what a small cola can. So actually it used to be, let me do it this way because I don't want them saying it's branding. It used to be $3.30 and then they were off the shelves for a long time and they came back 300 mils. But also we pay sugar tax, so I suppose it's better if it's less. Also, hey Annabelle. So Brandy, Evie collected a deer's leg and decomposed it and kept the bones. It was dead already. I feel like you guys would have that in common. Like it's not really. Where did I put this thing? Yeah, this is the most Gen. What are you again? The most Gen X thing you've ever said. Back in my day, we used to pay $1 for sweets. No, I'm joking. Oh my gosh. See, I knew you guys would have that in common. Okay, I found it. StreamYard. There. Don't know if closed captions are going to work because this is my own upload, and apparently YouTube hasn't made a way to. Oh, you can't see me now. YouTube hasn't made a good way to do the auto caption thing. Our prices went up and the portion went down. Yeah, but also Angie, I feel like that with our electricity, but we haven't had the L word in a long time. We actually missed this morning. I was playing funny Parliament moments. Right, let's trial. I could basically stay here in this little box.
Can you don't pull on my computer?
We can.
Okay. Is that mine or is that that's what it's like?
Give us one. That's you.
Okay.
Right?
Yes.
Okay.
It's just on 3.5.
Don't worry, I'm just messing
Good
with you.
afternoon, ladies and gentlemen. I'm going to cover a lot of the same ground as Ms. Jeffcoat because honestly, the charges and the elements of the offenses are
What did I do? Really? My own? Really? Really? Just got recommended my own video and clicked on it. Guys, I lost it. I lost it. And the video too. Oh, I can't say it in oh, Angie, if it starts tomorrow, that's on you. I just took the rechargeable bulb out of that light. If it starts tomorrow, I'm going to be very annoyed with you. Guys, this is not a drill. The video's gone. And it's my own video. Literally, it's gone. Can you guys still see me? I'm very confused. Just give me a minute because I have, okay, you can still see me, so at least I'm not stricken. I should be able to get it from the Premiere. They're watching something in Recovery Addict. Adam left us and went there. Or he's double YouTube streaming. They're showing something to do with Karen Reed, but I don't know. Okay, this is annoying. Because I set it as a premiere, it won't let me see the video. So I'm actually just going to put it back on private. Not a good day to mess with me. Okay. Wait a minute. Can you guys hear the airplane? Wow. Someone go tell Adam in RA's chat that Brandy's weird too. No, I'm joking. We're all weird here. That's why I like it.
Others. In order for negligence to be culpable, it must be gross and flagrant. Culpable negligence is a course of conduct showing reckless disregard of human lives or of the safety of persons exposed to its dangerous effects, or such an entire want of care as to raise a presumption of conscious indifference to the consequences, or which shows a wantonness and recklessness or a grossly careless disregard for the safety and welfare of the public, or such an indifference to the rights of others as is equivalent to an intentional violation of such rights. Okay, so let's talk about that some more, and then we'll talk about that.
I haven't seen that.
Last one. So the defendant's actions, and I'm talking specifically about not just his actions towards the officer that day, but his general mood. You know, the first officer that testified, he got called out there initially because the defendant was refusing to have cuffs placed on him. And by the defendant's own admission, he was having a moment. He was acting erratic, I believe were what his words were. And this is according to the defendant. He was having a moment, snapping off and erratic. And that was even before he got into the institution. And then he said while he was working on his numerology and his letterology, that he was snapping off at that time. And so there's an issue that requires Officer Dosick to come out there. But at the time, he is somewhat amenable. He knows what's going on because he agrees to go with the officer to meet with the captain, and he doesn't have to be hauled down there or dragged down there. But apparently when he is meeting with the captain, he is still having some issues because the request is simple at this point from the captain. It is to cuff up, which is a standard practice at a DOC facility. And this wasn't his first day there. He had been cuffed before. And so when they try to cuff him, he ends up, picking the officer completely off of the ground. And the officer is bigger than the defendant. There's no question about that. But he ends up picking him up and bringing him down with enough force to cause major and serious injury. Okay. And so that behavior of other
Can you don't pull on my computer?
Captain Sanders originated from the broken.
I went forward because you were a bit further back.
Femur, which occurred on March the 18th when Joshua Lawson threw him onto the concrete sidewalk there in the DOC facility. So with that, members of the jury, I will ask you to find the defendant guilty of the offense of aggravated manslaughter. Thank you.
Is the defense ready to proceed?
Yes, Your Honor.
Ms. Kelly, you may proceed.
Thank you, Your Honor. Can you don't pull on my computer?
We can.
Okay. Is that fine or is that, because that's what it's like.
Give us one. That's you.
Okay.
Right?
Yes.
Okay.
It's just on 3.5. Okay. Good afternoon, ladies and gentlemen. I'm going to cover a lot of the same ground as Ms. Jeffcoat because honestly, the charges and the elements of the offenses are really why we're here today. I mean, the evidence is the evidence. You've seen the video for yourself. So the elements of the offenses is the big question here. I'm going to start out, and all these slides are going to be included in the jury instructions that go back with you. Starting out with, judge is going to instruct you on reasonable doubt and burden of proof. An accused person is assumed not guilty or innocent unless that presumption has been overcome by the evidence. So the evidence is what we hear today. The state has the burden of proving the crime was committed, that a particular crime was committed and the defendant was the one who committed the crime. We're not questioning who all was involved in this incident. We're only here about what the actual crime was. A reasonable doubt as to the guilt of the defendant may arise from the evidence, conflicts in the evidence, or a lack of evidence. And the defendant is not required to present evidence or prove anything. So those are just kind of some basic things to keep in mind. One of the other instructions, I'll get to that in a minute. So Ms. Jeffcoat kind of went over the elements. This is for battery. She addressed that. Battery of a law enforcement officer. We went through all of those elements. Felony battery. Aggravated battery. What's important here, and Mrs. Jeffcoat address this is the big difference between aggravated battery and felony battery is the intent. So felony battery says, okay, you did an act, you intended to do the act, and that act resulted in great bodily harm, permanent disability, or permanent disfigurement. So that's felony battery. But aggravated battery requires that you intend to do that great bodily harm, that you intend the effects of that. So it's not something where you can, it has to be foreseeable. It has to be something that you can foresee coming, that you intend to happen. And so I'd argue that in this instance, Mr. Lawson never intended any injury to Captain Sanders, that it was a quick spur of the moment, evasive maneuver. Mr. Lawson is 5'5", 120 pounds. Captain Sanders was 6'2", 220 pounds. There's almost a foot difference and 100 pounds difference between the two of them. And Ms. Jeff had addressed this earlier, but kind of some things that I have highlighted here that I think are of particular importance. So if there is a violation of this duty of reasonable care, if there is no conscious intention to do harm, that violation is just simple negligence. It's not culpable negligence, it's just negligence. Culpable negligence requires a course of conduct showing a reckless disregard for human life. This is something like if you don't feed your baby for 2 weeks and the baby dies, or if your grandmother you don't take care of your grandmother and she succumbs to an injury. This requires a course of conduct. This isn't just a spur of the moment split incident. Excusable homicide, this applies is one of the instructions that the judge is going to read to you. What is of note here is when passing all of this legislation, when our lawmakers were looking at things that happen, things that they look at right here under subsection 2 is when a killing occurs by accident and misfortune in the heat of passion or upon any sudden insufficient provocation. So that's, you don't intend for anything bad to happen. It's a sudden kerfuffle. And then 3, when the killing is committed by accident and misfortune resulting from a sudden combat, when there's no dangerous weapon present and it is not done in a cruel and unusual manner. The point of this is the legislature realizes that there are times when fight or flight takes over, when there are times when we don't have time to reflect. And so they want to address that by saying there are certain circumstances where what would otherwise be a homicide are not homicides. Ms. Jessica addressed the elements of aggravated manslaughter, but once again, I'm going to highlight the notes that come with those further instructions. The defendant cannot be guilty of aggravated manslaughter if it was the result of a merely negligent act. And once again, without any conscious intention to harm, that violation is simple negligence. It requires a course of conduct. So it's more than just one thing. It's an ongoing course of acts. Here we've got manslaughter. One of the instructions you're going to have here is every person has a duty to act. And if there's no violation without any conscious intent to harm, that's negligence, and the defendant cannot be guilty. We had an expert witness, that was Dr. Radke. This is the instruction on expert witnesses. An expert is only reliable as to what you believe them to be an expert about. And then this is the image that sticks with me. This is a few seconds before the immediate contact with Captain Sanders and Mr. Lawson. As you can see here, Mr. Lawson is trying to disengage. He's trying to walk away. And I'm not sure, but to me, and you're gonna have to use your own judgment, but it appears right here that as always pepper spray. And Mr. Lawson told you from the witness stand, he was simply trying to de-escalate the situation and get some space. One of the other issues here is going to be causation. Mr. Lawson indicated to you that he was engaged in this physical conflict with Captain Sanders. But some of the things that we need to look at in reaching a verdict are the factors involved in Captain Sanders' death. His wife told us that on the morning of his death, unfortunately, they had been to the doctor's office. He had complained of some symptoms, and the doctor's office ignored it. The doctor's office said, "You're fine, go home," after he had complained of coughing up blood. his wife had indicated to us that he suffered from diabetes, which is has circulatory issues related to it, that he had a history of cancer treatments, that he would walk around at work and he would cut grass, but he wasn't a routine exerciser, that he was on high blood pressure medication. These are all things that contribute to blood clots. These are all things that should have been addressed by his doctor. If there was any culpable negligence, in my mind, it was on behalf of his physicians who sent him home after he reported coughing up blood. They didn't give him any compression stockings. They didn't provide him with any blood thinners. There was an absolute failure by the medical profession on behalf of Captain Sanders. Dr. Radke told us that the blood clots occur in about 1% of these cases. So I submit to you that Captain Sanders' death was not foreseeable as a result of the actions of Mr. Lawson, and that the negligence that occurred was on behalf of the doctors who failed Captain Sanders. So with that in mind, I would ask that you come back on a lesser offense. It is not the belief of myself or Mr. Lawson that he was the cause of Captain Sanders' death. He certainly bore no ill will to Captain Sanders. They had never met. They had no prior disagreements. Thank you for your time.
Is the state ready for its rebuttal?
Yes, Your Honor.
You may proceed.
Members of the jury, we are at the close of the trial, and Ms. Kelly is right. A person who stands accused of a crime is innocent until proven guilty. They are presumed to be innocent. But he has been overcome by the evidence, and he is no longer presumed to be innocent at this time, because the evidence indicates that but for the actions of Joshua Lawson, Captain Sanders would not have received an injury that day. Now, the defense has talked a lot about things that could have been like cancer or his workout routine, or what the doctors did or didn't do. Okay, but those are all speculation. And recall the jury instruction that we talked about during voir dire, beyond a reasonable doubt, and the judge will read that to you. And again, proof beyond a reasonable doubt is not proof beyond all doubt. That's the beginning of that paragraph of the instruction. But then it goes on to say that a reasonable doubt is not a mere possible, speculative, imaginary, or forced doubt. Such a doubt must not influence you to return a verdict of not guilty if you have an abiding conviction of guilt. And members of the jury, in this situation, there is no other evidence as to what caused the injury and ultimately the death of Captain Sanders other than the defendant's actions. Now, the defendant did testify that he did not intend to harm the officer, but he did admit that that was him on the video tossing the officer to the ground. You also have to weigh his credibility. And one of the things that the court will tell you about credibility, there's a list of factors that you can consider. One of those is, has the person been convicted of a felony? Well, the only person to testify before you all today that has been convicted of any felony is the defendant, Joshua Lawson. He has 4 felony convictions. Also, whether or not the evidence seems to fit with other evidence in the case. And the defendant made some other kind of odd statements about things that did not appear to happen on the video, like the officer's glasses came off his face when he was adjusting his belt, I think is what he said. And so those are things that do not line up with the other testimony evidence in this case. This is a unique situation because the circumstances leading up to this aggravated manslaughter and the injury itself are all caught on video. And so you can see exactly what the officer or Captain Sanders and the other officers are doing and what the defendant is doing. Did he back up? Yes, absolutely he did. But this is not the same as a situation of 2 people walking up to each other on the street. The defendant is an inmate at a correctional institute. He is being held there as punishment for crimes that he has previously convicted. And so if he wanted to de-escalate the situation, all he had to do was submit to hand restraints. That is all that the officers had asked him to do throughout, and he continued to refuse to submit to hand restraint. So when the officer went to physically put the hand restraint on him, which he is, required to do as part of his job, is when the inmate, picked him up and threw him to the ground. Okay. Recall, if you will, the testimony of Officer Myrick and Officer McCrary. They specifically use the word body slammed, that Captain Sanders was body slammed by the defendant. And the resulting injuries to Captain Sanders are completely and totally foreseeable to body slamming an individual onto a concrete sidewalk. Members of the jury, we talked in jury selection about negligent acts, about foreseeable acts, and his act of body slamming the officer onto a concrete sidewalk, it is the shooting of the firework in the gas station. The resulting injury, the resulting hip fracture, or femur fracture, is a foreseeable consequence of that type of action. And so, members of the jury, the defendant has committed battery by touching or striking the officer. He's committed felony battery by causing serious injury. He's committed aggravated battery by doing an act that he knew or should have known would cause that type of injury. He has committed manslaughter, both by committing an intentional act of throwing the officer, which ultimately killed him, as well as through culpable negligence by acting in a way that disregarded the safety of Captain Sanders. And he has done all of this against the law, against and in violation of the laws of the state of Florida. So, members of the jury, there is no question that the defendant's actions resulted in the death of Matthew Sanders, and he should be held accountable for his actions. He is an adult, and all adults must abide by the laws of the state of Florida. And in this case, Your Honor, members of the jury, we would ask that you find the defendant guilty. Thank you.
Amanda. Members of the jury, I thank you for your attention during this trial. Please pay attention to the instructions that I am about to give to you. Joshua Lawson, the defendant in this case, has been accused of the crime of aggravated manslaughter of an officer. Joshua Lawson is accused of aggravated manslaughter of an officer. Aggravated manslaughter of an officer includes the lesser crime of manslaughter, all of which are unlawful. However, a killing that was excusable or that was committed by the justifiable use of deadly force is lawful. If you find Matthew Sanders was killed by Joshua Lawson, you will then consider the circumstances surrounding the killing in deciding if the killing was aggravated manslaughter or whether the killing was excusable or resulted in justifiable use of deadly force. The killing of a human being is justifiable homicide and lawful if necessarily done while resisting an attempt to murder or commit a felony upon the defendant, or to commit a felony in any dwelling house in which the defendant was at the time of the killing. The killing of a human being is excusable and therefore lawful under any of the following three circumstances. 1, when the killing is committed by accident and misfortune, in which any lawful act by lawful means with usual ordinary caution and without any unlawful intent. Or 2, when the killing occurs by accident and misfortune in the heat of passion upon any sudden and sufficient provocation. Or 3, when the killing is committed by accident and misfortune resulting from a sudden combat if a dangerous weapon is not used and the killing is not done in a cruel or unusual manner. A dangerous weapon is any object that will likely cause death or great bodily harm if used in the ordinary and usual manner contemplated by its design or construction. Great bodily harm means great, as distinguished from trivial, slight, minor, or moderate harm, and as such does not include mere bruises. I now instruct you on the circumstances that must be proved before Joshua Lawson may be found guilty of aggravated manslaughter of an officer or any lesser included crime. To prove the crime of aggravated manslaughter of an officer, the state must prove the following three elements beyond a reasonable doubt. 1, Matthew Sanders is dead. 2, the death of Matthew Sanders was caused by the culpable negligence of Joshua Lawson. 3, Matthew Sanders was an officer who was at the time performing duties that were within the course of his employment. Do you guys need to approach? I'm happy for you to. Come on up. I don't need a court reporter. I'm going to restart the instruction on aggravated manslaughter to make sure that I have not misread any portion of it. To prove the crime of aggravated manslaughter of an officer, the state must prove the following three elements beyond a reasonable doubt. 1, Matthew Sanders is dead. 2, the death of Matthew Sanders was caused by the culpable negligence of Joshua Lawson. 3, Matthew Sanders was an officer who was at the time performing duties that were within the course of his employment. Every person has a duty to act reasonably towards others. If there is a violation of that duty without any conscious intention to harm, that violation is negligence. The defendant cannot be guilty of aggravated manslaughter by causing a death because of a merely negligent act. But culpable negligence is more than a failure to use ordinary care towards others. In order for
Sorry, if I don't say this now, I'm gonna forget. What I liked about Vyvanse is, what I liked about asking my doctor for Vyvanse is she let me do it in 3-day stints. So I didn't, like, all of my meds I've tried has been like 3-day stints. So I don't have to commit to it because I'm so scared. Like with, what was it? It was one of the concerted generics. Was it Mucon maybe? No, it was Contramil. It gave me such bad heart palpitations and like I felt sick all the time and I just felt awful. So she lets me try it in like 3-day increments because it's more important to me that my body feels normal. So you actually did pick them instead. Brandy, the shortage should be over now. It is here at least. Okay. Guys, should we skip this? The instructions. There's that ADHD, 100%. I'm like, my meds wore off. I don't know if anyone else feels like this, but I feel like if I have to use my brain more on a certain task, then it's like it uses more of the meds, you know? Like the meds last for 8 hours. But if I have to do something that takes 150% mental capacity, then I only have like 2 hours of brain. Like it feels like it lessens it. If I go all in, and I was on such a roll, but I didn't finish the script I was writing. Yes, skip. Okay. Love this because I get so bored. And for those who want to watch the jury instructions, you can watch tomorrow's video. Okay.
number and come back out and give us all of your electronic devices and leave those on the chair. Any questions about the logistics? All right, let's everyone remain seated as our jurors leave the courtroom. Mr. Trial, you're welcome to go grab your stuff. If you'll leave us the juror button, that would be great. And we are all sitting tight in the courtroom and you are welcome to stay with us or you're welcome to leave with our most sincere thanks for your time serving.
Thank you.
Okay. Do you want us to call you and let you know what happens?
Yeah.
All right, we'd be happy to. Thank you.
Aww.
The jurors are not present in the courtroom, however, still present in
Brandy, important point. We need a poll. Ask a question. What is your verdict? Guilty. Not guilty. Lesser included. Such a bummer that I can't vote. Brandy, also, it could be because we have, don't know who Vyvanse is made by, but we have GSK, Johnson & Johnson. We have a lot of like pharmaceutical places here. So I don't know if they're locally. Lesser deported. This is the thing that's making it hard is like if he didn't hurt him, he wouldn't have broken his leg. Where I'm torn, my vote, what's getting me a little confused is like I can't tell if this was a classic case of a corrections officer that had to be like the authority, you know, if it was like a little bit of an alpha ego struggle situation, because his vibe, the inmate's vibe, just doesn't match the idea of what they've painted. He doesn't seem like, I mean, obviously he's in there on 4 felonies, but we also don't know what those 4 felonies are. And I tried to look this guy up and I couldn't find anything. If anyone else wants to try, this is his name. And he's 28 years old. I don't know what the felonies are. He pled guilty to all 4 of them at the same time. They could be something relatively small. And I don't know. I think I've seen too many things about corrections officers being like treating people like they're less than because they're in jail. Like, yeah, so mine came back. He did say it's a bit agitated. Yeah. So what's cool is after the verdict, I don't know what the verdict is, I skipped it, but when I came to pause the recording, he was telling the judge his life story. And so we get to hear a bit of that background. That's exactly what I think, Brandy. Too much work. They do have to comply, but I also think that like you need to understand the personality type. Like they may be in there because they have problems with authority, and then you're more likely to get through by using a different way. Like, you know, the best thing I can think of is like when I used to au pair, I would have to tailor my discipline to whichever kid I was speaking to. Some kids, you can be like, don't do that. Oh, Brandy, did you see the verdict? Oh. Some kids I can be like, hey, don't do that, and they'd be okay. Some others would get upset. Some you need to be like, if you do that, you could hurt yourself, and let them figure it out, right? Like, if he has a problem with authority, then it is supposed to be a rehabilitation facility, not just like keeping people away from society. It's not, yeah. I can't remember where I was going with that, but anyway. Pays to be lazy. Maybe in there when they're innocent. Exactly. And I'll save this conversation for another day, but that is one of my problems with the death penalty. And people want to rag on no juries. You know how seldom we have wrongful convictions? Very, very, very seldom.
Present in the courtroom is counsel for the state and counsel for the defendant and the defendant. We had some errors in the jury instructions. And so what pages do you have? I have more than one page. Oh, yeah. I need one of your clean instructions.
Don't let me forget my verdict music.
Now I'm all. Without that extra. Because, okay, so wait, let me have that. Okay, let's be clear. Where I thought it needed to be changed and what I actually read is in an introduction to homicide. Okay, an introduction to homicide, aggravated manslaughter of an officer. Okay, so let me not confuse this. Do you want to put it back up real quick? I think you changed it, but I don't think you guys printed the last version. So perhaps if you just print the last version.
Your Honor, the stuff I'm looking at, it reads introduction to homicide, Joshua Lawson is accused of aggravated manslaughter of an officer. Aggravated manslaughter included the lesser.
Right, but that's of an officer. It needs to say of an officer, and that's how we changed it.
Okay, I didn't think we changed that, but I thought we changed it everywhere else, but it's okay.
No, I think we changed that, and that's how I read it. And then can we put prosecutor PC on the TVs, please? Pull, without making any changes, pull what you got, because we changed all this. And I just think it didn't get printed right.
This is boring.
Courtroom is counsel for. Are there any matters that we need to consider outside of the presence of the jury? Ms. Kelly, do you want to look at these instructions? Here are the jury instructions. We've got the verdict form and the. Ladies and gentlemen, Madam Clerk is about to give you the jury instructions, the verdict form, and the exhibits, and you may now retire to begin your deliberations. So thank you. Chuck, why don't you do it? It's okay, no problem. Let the record reflect that the time is now 3:08 p.m. Still present in the courtroom is counsel for the state, counsel for the defendant, and the defendant. The jurors are not present in the courtroom. Counsels, are there any matters that we need to consider outside of the presence of the jury at this time?
No, Your Honor.
All right, then we'll be in recess until we hear back from the jurors. All right. You're back on the record at 5:10 p.m. We're still here in the case of the state of Florida versus Joshua Lawson, Jackson County case number 21610 CF. Present in the courtroom is counsel for the state, counsel for the defendant, and the defendant. The jurors are not present in the courtroom. However, they have advised the bailiffs that they have a verdict. Are there any matters that we need to consider before we bring them in?
No, Your Honor. Nothing further, Your Honor.
All right, let's bring the jurors in. Everyone remain seated, please, sorry, Gary. Family members, we can only imagine how incredibly difficult this entire situation has been for you. That said, I will not allow anyone to have any visible or audible response, whether it be of joy or of sorrow, when the jury verdict is read. Okay, so if you feel that it may be too difficult for you to sit in this room and have no response, then I would ask you to please leave the courtroom. Otherwise, you will be removed from the courtroom, okay? Because while these jurors are in here, I will not allow any emotion shown by the gallery. Once the jurors have left, you are free to show whatever emotion you wish. But while they're here, we don't do that, okay? All right? All right, let's let the jurors come back in. Everyone remain seated.
Ladies and gentlemen, please take your seat in the court.
Welcome back, ladies and gentlemen. Ladies and gentlemen of the jury, have you reached a verdict? All right, if you can please give the verdict to one of our bailiffs who will pass it along to me. Madam Clerk, please publish the verdict, and will you do so on the mic?
Thank you. I got sidetracked. Let me make myself a little bit bigger. I got sidetracked looking for the wrongful convictions. So this is the thing as of 2018 in South Africa. But they did say that wrongful convictions are a problem in recording. I just want to go back up quick. No, I'll do that after. Here we go. Brand, music. Are you ready? Let's make it loud. Warning, I'm going to make it a bit louder. Can't do it as smoothly as I can normally.
You can turn it your way. That'd be great. Thank you, Madam Clerk.
In the Circuit Court, 14th Judicial Circuit of the State of Florida, in and for Jackson County, State of Florida versus Joshua Lawson, case number 21 CF 610. We, the jury, find as follows as to the defendant, Joshua Lawson, in this case. The defendant is guilty of the lesser included offense of aggravated battery on a law enforcement officer. So say we all, dated this 25th day of June, 2024.
Do either the state or the defense wish for the court to poll the jury?
Yes, Your Honor.
Madam Clerk, please poll our jurors.
Mr. Allen, is this your verdict?
Or your deliberations may come as you of some very special privileges enjoyed by jurors. No juror can ever be required.
Wow. I think I guessed it. Yay! We love the verdict music. Well, you guys chose it, so. Hey, Brian and Jill cleaning out the roommate's car. He's messy. True Crime Kitty, did I say hello to you already? I can't even remember. The number of years that have been served. Yep. But I mean, like, let me go back up. That's what I was looking for. I was looking for Brandy's stats. The stats for last year in CA alone on innocents being held in custody is 7,000. Listen properly. 7,723. Guys. Oh, my numbers are like my ex-presidents. Give me a minute.
Our membership figures stood at 700, listen properly, 769,820 and 70 members, down from 100.2 million in 2012.
Let's try that again. 723,000 in a year. You guys need to, I know this is going to be the most random recommendation I've ever made, but Kim Kardashian's podcast on the wrongfully convicted guy. Oh my gosh, it is so good. It is so good. That was so loud in my own head. Woo. This case is the one, oh, Steve's already explained it, so I'm not Yeah, it was weird that she called the cop up. That was weird. Now where am I? Looks like he got his felonies from lots of failures or hiding. It says assault or battery. Closest I've ever been to a rave. What? What? Trying to find his 2014 stuff for free. If there's paywalls, you can use 10foot.io. I was asked by one kid, aren't you kind of old to be at a rave? I answered, aren't you kind of young to be on drugs? Listen properly. Wait, Evie, is that brain buffering or me buffering? I forgot where I was going with this. We need to go back to court. Oh, now I'm so small. My cousin said that I need to go to Ultra Music Fest with him when he turns 18. And I was like, I'm going to be 40. And he's like, that's okay. This last year when we went, I felt like we were going to be the oldest people. And there were people like old enough to be our parents. So I don't feel so bad now.
Required to talk about each of you, whether to correct. Is that what the defense understands as the first degree felony? With your buttons and collect your electronic devices, and you can leave all of those on the chair. Everyone may remain seated and the jurors are free to go. Thank you so very much, guys. All right, Let the record reflect that the jurors have exited the courtroom. Ms. Jeffcoat, the defendant was charged with the first-degree felony and if essentially was found guilty of a lesser included offense. However, it's still a first-degree felony punishable by the exact same amount of years as the original offense. Is that correct?
That is correct.
Is that what the defense understands as well? May I see counsel at sidebar, please? Can I have the white noise? No court reporter. Counsel, we've had an off-the-record conversation about the propriety of proceeding with sentencing at this time. The court asked or ordered that inmate Lawson be transported from the Department of Corrections where he is currently being housed. Deputy Hodges with the Jackson County Sheriff's Office actually transported him, and I think he just stepped out to walk the officers out. But he is currently housed in the Florida Department of Corrections. Is that what everyone understands to be the case?
Yes, Your Honor, and Inspector Bassford's president can also confirm that, but we did orders to have him transported for the purposes of this trial from the Florida Department of Corrections.
All right. Where's Hodges? Can we get, because he's the one who actually got him from, where's Hodges?
I sent him down with Deputy Spades to escort the jury.
Could you get him back when they're done? And just for a minute, because guys, what I'd like to do is sentence right now, if we can make that work. So, and I'm happy to consider any arguments that you will make. Would everybody be ready?
Yes, Your Honor, I can do that.
All right. Deputy Hodges, if you don't mind coming on up, will you come to one of the microphones, please? Deputy Hodges, if you will raise your right hand, do you solemnly swear or affirm that the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth?
Yes, I do.
All right, Deputy Hodges, last week sometime, you got inmate Joshua Lawson from a DOC facility and you transported him to the Jackson County Jail. Is that correct?
That's correct.
All right, and where did you get him from?
Florida State Prison located in Rayford, Florida.
All right, and that's where you are to return him because he's still serving a sentence there. Is that correct?
That's correct.
All right, and that's pursuant to my court order, correct?
Yes, ma'am.
All right. Any additional questions by the state or the defense? All right, do you want any testimony regarding the sentence that he's currently serving?
Your Honor, I can just, if Inspector Bassford, I think, can confirm that he is still actively serving the sentence.
All right, so let's just get him up here. So Investigator Bassford or Inspector Bassford, if you don't mind coming up. Do you know the actual current sentence? No, but
No.
you know that he's currently serving a sentence, and certainly Officer Hodges' testimony
I could get that.
would be sufficient. Why don't you take a minute?
I can get that confirmation. If you give me just a few minutes.
Yeah, that's fine. Why don't you take a minute and then the attorneys can take a minute to look at everything, and then I'm happy to hear any arguments, and that way hopefully we can give some closure to the whole situation, okay? Inspector Bassford, can you come on up? Inspector Bassford, you're still under oath from earlier today. You currently are employed with the Department of Corrections, is that correct?
Yes, ma'am.
All right, and can you tell us whether Joshua Lawson, the individual on trial today in Jackson County, is an inmate with the State Department of Corrections?
Yes, ma'am, he is.
And is he currently still serving a sentence with the State Department of Corrections?
Yes, ma'am, until his current tentative release date is March the 5th of 2027.
All right, fair enough. Can you share with me what he's currently serving a sentence for?
Robbery with a gun or deadly weapon, grand theft motor vehicle, and attempted robbery. So there's looks like 2 counts of robbery, 1 count of attempted, and 1 count of grand theft.
Total 4 felony offenses?
Yes, ma'am.
Is there any objection or does any follow-up questions to the information elicited by the court?
No objection, Your Honor, and the record is stated by Inspector Bassford of the 2 robberies, the attempted robbery and the grand theft, are consistent with the certified convictions that we
Of
got.
4.
Is it bad that my brain kind of went, well, that's not that bad? Maybe I've just been true crime writing too much today. But my brain was like, oh,
Fair enough. Anything from the defense on that issue?
No, Your Honor.
Thank you, Inspector Bassford. State, whenever you're ready, let me know, and if you need some time, let me know.
Certainly, Your Honor. The defendant has been found guilty of aggravated battery under Florida statute 775.082 subsection 9. It defines.
Most specifically 9A1, right? Okay, I'm with you. Go ahead.
It defines a prison releasee reoffender as a person who commits or attempts to commit one of the enumerated offenses, and under subsection K, it lists aggravated battery. And then it states within 3 years after being released from a state correctional facility by the Department of Corrections, or within 3 years after being released from a state correctional facility operated by the Department of Corrections, a county facility, for the sentence pronounced. Or
well, I
following
despise you.
incarceration for an offense for which the sentence is punishable by more than a year. It also means that the defendant, under subsection 2, so that would be 9A2, it says, it also means any defendant who commits or attempts to commit any offense that's enumerated, which includes subsection K. While
Blah,
the
blah.
defendant was. Your Honor, I believe the defendant is entitled to credit since his warrant was served in this matter. The state would ask that this sentence be run consecutive. He still has a few years left on his original sentence. Also, just for record purposes, the state had previously sent a plea offer in the case, which we've gone over on a record before a prior jury selection. And in the email in which I sent the plea offer, it does indicate that I had a discussion with Ms. Kelly that he would qualify as a prison releasee reoffender. And it's my recollection that we also put that on the record with the defendant before picking not the jury for this instant case, but when we attempted to pick a jury and did so last 2 months ago.
When was the warrant served?
And Your Honor, I just was doing math in my head. I believe I misspoke. I just pulled it up from my jail credit from my computer system, and I believe 2,065 days would have been from the date his original sentence commenced, because it's way too long. So
February 10th of 2022. Madam Clerk.
Way, basic law, the widow.
I believe I misspoke. I just pulled it up.
Sir, the warrant for this offense was served on February 10th of 2022.
So as of today, Your Honor, the calculation that I've come up with is 866 days.
For which case? For the chart.
From February 10th.
That's not relevant to this. Yeah.
Does the defendant wish to be heard?
You want to address the board? No, Your Honor.
All right. Does any representative of the victim's
he
family
does.
wish to be heard?
Your Honor, Mr. Thomas Weeks would like to speak on behalf of the family. He was the brother-in-law of the deceased.
Sure. Mr. Weeks, if you don't mind, please come on up to one of the microphones. Okay. Mr. Weeks, I'm happy to hear and consider anything that you wish to say on behalf of the victim's family.
Yes, ma'am. My sister-in-law, the widow, Matt's widow, and his daughter, they don't feel like they could stand up here and speak because it would be too painful for them. Mr. Lawson took away not only a father to Megan, he took away Winona's husband, he took away a brother, he took away my friend, he took away a grandfather of a little girl that'll never get to know her grandfather. The little girl is, she's 8, she's autistic. Matt had a great relationship with her, and now he's gone. He's gone, she doesn't understand that. And it's been very difficult. It's been a very, very difficult time for everybody. And we're just happy to finally be here and see maybe some justice served. I'm not going to go into opinions and everything about the jury verdict and all that. That's not what I'm here for. I'm here for you, Your Honor, to ask you to just hear that and know that he has taken away basically lives. He's taken away basically lives. For a long time, my sister-in-law wouldn't leave the house. She couldn't do anything. For a long time, my niece, I had to check on her daily. I'm the one.
I feel you, Jill. I feel the same. And I'm just wondering if like on a Friday night is when we want to listen to it, because this video is going up in its entirety tomorrow. So like if people want to listen to it, it will be there. It's not like it's gone forever, but I feel like we're all kind of like a little flat. I mean, I can make a poll again. Please don't make me make a poll again. Because Judge Simpson's back, Judge Fleischer's on. We can go with whatever. I need to catch up on this. Obviously, I'm a woo girl. I do this. Like, that should be so obvious. Also, don't rewatch How I Met Your Mother now. It's not funny, and it's just... I was so disappointed because I remembered it so, like, I just want to keep it in my head as it was. Also because now I've watched Friends 5,790,000 million times. I see how much How I Met Your Mother wanted to be like Friends. I like to hear the real stories. Oh, Jill, you can share. Hey guys, it's a Friday night. It's a Friday night. I want to try this thing. Okay. Maybe we should try find some celebration music. It's not even so much problematic. Like, it's a little problematic, but it's also just like, I remember it so fondly. It doesn't feel the same. Oh, they have AI voice now in this thing. Music. Share this tab instead. Party. We like to party.
I just need a reason.
Whoa.
I just need to know what's on your mind. Tell me what you're needing. You can call my name, I'll be around. Dum da da, dum dum da da, dum da da, dum dum da da, dum dum. The sky is falling, dum dum da da, dum dum da da, dum da da, dum dum da da. That will keep you safe and sound. Dum da da.
It's a little easy.
I'm so fast forgiving, 'cause you're the one to blame. It's all forgiven, addicted to the game. I can't tell the difference, just show me the way.
This is a vibe. I don't know about that. Whistles? No. We need something that's just like, yay, we did it. That's it, just like happy. Heavy lifting. It says my bitrate is lower than recommended. What kind of music are we feeling for the happy stuff? You guys think about it while I try to figure out which tabs I can close. Rock and roll. I would do rock, but like it feels like if we're doing a happy thing, it must be like something like doom, 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 doom.
Lose control tonight. You gotta move your body, everybody.
I mean, no offense to that person. That feels like it should be illegal. African living world. What is that? Okay. Guys, I don't know. It's like too many decisions. Feels so good. Oh, duh, Joan Jett. I love rock and roll. You weren't saying that she loved rock and roll. Oh, Vicky Mac. Guys, I'm about to give up. I'm about to give up. We're about to just say yay without any music. Because I just want to watch either Judge Fleischer or Judge Simpson. Somebody else make a decision. I can't make decisions. Chilling in Cape Town. Anthony Vega.
Yeah.
Really, Anthony? Really? Do you even live in Cape Town? I don't think you do. No, honey. That's not what Cape Town sounds like. Nope. Nope. King Lion? No. 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 I like watching your music brain. No. I sold it. Unfortunately. It was Vaughn's first gift to me though, and I was like, damn. That's a lot of cash for a first gift. I loved it though. I just had to retire because I couldn't DJ without drinking. I can't. People. Woohoo! Concert. There's nothing like a concert. We're going at one several hours before the concert because she's known to walk. Oh, that's so cool. Okay, where are we going? Are we going Simpson? Are we going Fleischer? Are we going home? Evie, you said 1 hour. I'm on Instagram, you girl. You said 1 hour and you'd show your plants. I should just make my own, but I don't think I can remember how to. No, I'm sorry, but I think it does have to be electronic. It probably does. Otherwise, it doesn't fit the theme. Anyone remember where we got the verdict music, what I put it under? No, guys. Nope. Sorry. We're celebrating without Simpson. We're celebrating without music today. Okay, Instagram. Is that where I sent it to you last time, maybe? I don't even remember. My Instagram right now, keep forgetting to post or anything. I am solely using it for an inbox. Okay. While Evie gets her life sorted.
You passed this case, Miss Thompson came into the courtroom, indicated that she was going to post escrow, and she has been down in the clerk's office since.
Miss, okay, so
Oh,
she was gonna post escrow?
That's what she said to me from the gallery. I confirmed she's in the clerk.
so the judgment amount was for $1,832.37.
Correct.
That included May only. And so
Correct.
the issue, of course, is that at present, there is a total due of $2,851 and some change. The court costs are slightly off on here, and so there's $1.87 more in my balance. So in essence, 2851-ish is the balance.
Yeah, okay, so 2851. I have 15 what?
1519.
I have 1519.
And with July, Your Honor, which obviously is due
Right.
Monday, the total will be $3,616.29.
You said 16 or 60?
16.
16, okay. All right. Ms. Thompson?
I ain't got nothing to say. I'm just asking for that. Sometimes you bite off more than you can chew, time and everything. Besides all that, no, the money is due next week for the 1st to the 5th. And my intentions is to pay it by the next court date. But what I'm asking you is a favor, just because this isn't the only thing, instead of saying, okay, I'm gonna take care of that whole thing next week or whenever the court day is, I'm just asking for 2 weeks for you to do it. And then 2 weeks after that, we'll put it in the middle of the month. If that is all possible.
Okay, I'm not sure what entirely you just asked me, but
Want me to explain?
well, let me point this out to you. The original judgment started out at 1832 and some change.
With figs and fig trees, you got to shake it to simulate. I can't even. Hi, Corey. What a time to come in to this chat. We are on, just a warning, we're on all the ADHD rabbit holes. We have not completed one single task. We have not watched an entire court thing through. We have not even finished listening to a song. We are all over the show. Evie's about to show her plants. And that's not a euphemism, that's not an innuendo, but it often is. Finally got my tomatoes planted this week. I have a bit of a tomato problem, to be honest. I thought that I had tomatoes, I thought they weren't growing. So I just chucked all the soil back into the container that has the rest of my soil. And then I used that over time. And now I have tomato plants growing everywhere, like weeds. But they give fruit.
Okay. You come up, you paid, and it looks like what you paid is each time you paid, basically, so that your monthly rent doesn't keep creeping up. Okay. But if, and Ms. Dornbush, just so I'm clear, the 3,616 did not deduct what we have.
That's correct. That does not take into account
Okay.
the 1519 in escrow.
Got it. Okay. So I've got about $2,000 plus or thereabouts that need to be, I'm right. No, I'm not. Yeah, I'm right. Yes, ma'am.
$2,097.29.
I was right. All right. So I've got $2,097.29 that's going to be owed for July. Okay, that's what I'm looking at. Okay. Now, you started out telling me you bit off more than you can chew. What are you trying to, what are you?
Not about the rent. It's just about the expectation for today. I didn't consider the fact that my son's surgery date was within this boundary, and it just made me not be able to do what I had intended. Only thing is, like I said, generally whenever I have came, I did everything paid before I even had to come back to court. But what I'm asking, instead of biting off more than I can chew, to say, hey, this whole thing will be done by, say, 2 weeks. I don't want to say that. I want to say is between the next court case, I'm asking.
No, just hold on. All right.
Mhm.
I'm listening to you. You're scared right now.
Of course.
Yeah. And you're trying to give me reality of what your circumstance is. I hear you, and I'm trying to keep up with you. Okay. And my thought process sometimes can be a little bit different, but I'm not in the circumstance, but I'm going to try to understand where you are. Okay.
Mhm.
Fair enough.
Correct.
Okay. So if I send this money to, well, let me ask you this. When's the next time you're going to have an amount to pay?
Actually, I would normally say, which it can be,
Okay.
in 2 weeks from today, which would be the end of the month technically. So
What do you mean that would be the end of the month?
today is the end of the month.
Yeah.
Okay, so no, I mean, like in 2 weeks, I will have, my intentions is to, and I know I will, $1,000.
Okay. So hold on.
Mhm.
So you're going to have $1,000 by the 12th.
Correct.
Okay. I'm going to do something absolutely over plaintiff's objections, but I'm sitting here looking at Ms. Thompson, and I think she's trying. And she was forthright with the court and saying, I promised too much. And she can't do it. So I'm going to, you still have the writ pending. So plaintiff has their protection. I'm going to release immediately the 1519 to plaintiff. I'm going to indicate that you're going to pay $1,000, and Ms. Thompson, you're going to pay that by the 12th. Ms. Thompson, if you come back in, I understand trying to do something and it doesn't work out and you're trying to do something else, but I'm not going to hear anything else. That 1,000 isn't in.
Okay.
Okay. I just can't. I have to be fair to the plaintiff in this regard. And I just can't do that.
I respect that.
Okay. And I will adjourn this out to the 12th to give her an opportunity to do that. And let's see if we can get her caught up at 2 p.m. And I do realize that is a plaintiff's objection, but I think she's trying. All right.
Thank
So
you,
we'll
Judge.
do that, and I'll make sure that amount gets released to the plaintiff right away. Okay, Ms. Thompson?
Yes.
I don't
Thank
see
you.
you yet, Evie.
Thompson, you're welcome. Ms. Thompson, always have faith, right?
Mm-hmm.
Okay. Have a great one.
And Your Honor, if I may, is it possible to have the Felicia and Reginald Hugan case recalled? Inadvertently, the July charges were included in that judgment amount, and obviously they're not due till Monday. And so I would like to
Okay.
correct the record with.
It already went down. All right. What would you like? I don't have the file, but we can correct that. What would be the amount? Go ahead, counsel.
Thank you. Your Honor, the total due with court costs is $1,896.52. And therefore I would submit a judgment by default reflecting that as the total redemptive amount.
And I will grant that judgment with that being the redemption amount.
Thank
And
you,
we'll
Your Honor.
get the file changed. Not a problem.
Okay. That's it for me. Have a nice day.
That's it. You do the same.
Your
Have a
Honor,
great
enjoy
holiday.
your day off. Enjoy the
I
holiday.
will.
See you on the 12th.
Yes, ma'am. All righty. Take care.
Hmm?
All right. That's.
Oh, because Thursday. Wait, guys, is Friday also off? Look at his face. Happy judge.
Pay that.
By themselves. Okay. They're handy up. If I don't see you. But I've reviewed. You may be seated. Let me take care of one other matter first. Detective Handy, oh, there she is. How are
I
you?
always want to
I'm
know
well.
how
How are
tall
you, Your
people
Honor?
are.
Ann?
Can you hear me?
Now I can hear you.
Okay, I'm well. How are
Yes.
you, sir?
I'm doing okay, I think. All right, I've reviewed your search warrant. If you could please raise your right hand. Do you solemnly swear or affirm the information contained in the search warrant and affidavit is to the best of your knowledge, information, and belief?
I do, Your Honor.
All right, very good. We'll sign this and we will get this back to you shortly.
Thank you so much. Hope you all have a
Thank
great
you.
weekend.
You do the same and have a good holiday if I don't see you.
Thank you.
Court calls the case of Mara versus Cold Scoops, DBA Bixby Coffee.
Cold Scoops.
Good afternoon, Your Honor. Jillian,
Wait.
plaintiff.
Good afternoon, Your Honor. James.
Wait, guys. We heard Cold Scoops. They were having an argument in a different court, and the lady was sitting at the van or something.
Mukherjee on behalf of.
And where are we on this case?
Your Honor, parties have agreed to terms to a consent judgment.
All right.
I can place those on the record?
Yes, please.
Thank you. This is a case for non-payment of rent. There is rent to retain possession of $27,151.68. Court costs are $188 for a total of $27,339.68. The statutory 10-day redemption period applies. And then under further orders, it states that this judgment will be set aside if paid in full honor before July 8th, 2024. I either have a copy with Mr. Mukherjee's signature on it, or I have a copy on the carbon copy paper, if that would be more convenient for the court, if Mr. Mukherjee wants to give me permission to sign his name to that.
All right. Either way, it's fine. All right. Whichever works for you guys. Mr. Mukherjee, is that a correct statement in rendition of the consent judgment?
That's correct, Your Honor. Thank you.
All right. Judgment by consent, redemption in the amount requested, writ issued by the A. All right. Thank you. I've signed that. We're all set. Thank you.
Thank you.
Have a great weekend and holiday.
Thank you.
Adam Vaughan said, "Stop fiddling
Strong
with your
Future
thing."
Homes versus Letitia Cochran.
Here.
I'm here.
Okay, Ms. Cochran's here and Ms. Maskell.
Since we're all paying such good attention to court, tomatoes are such a good one for that. And also, if it is, I didn't see why you can't plant it, but if it's because it is not indigenous, you can pot it and do it inside. Because like we have, I don't know what they're called, but it's a wandering dude, and it's not allowed. Same with ivy, and you can have them if they're not gonna spread. Well, ivy you're not allowed inside either, but I did get sold one by a nursery, and I was supposedly supposed to like call the environmental people, and I'm like, yo, bought it from a nursery. But if you do cherry tomatoes, they'll grow super easily. Or if you just get a little cherry tomato tree, then when the tomatoes fall in the soil, they'll also do it. Never had a fig. Oh, you need to have a fig. But it's got to be a good one. It's got to be a good quality one. It's got to be kind of squishy. Evie, no pressure, but I do need a wee. Ivy is invasive. So it will kill the indigenous plants. Just watch the people drop off. They're like, I just came here to watch court. Will you stop talking ish? Oh my gosh. Yeah, fig measuring. Some of us don't need to measure our figs, but you know. Proof is in the fig pudding. Where was I? Am I there? Oh yeah, mint is awful. Mint should be illegal to grow. Also, sometimes lavender. We've got the most insane. Wait, what do you guys even call this fruit? Is granadilla there? Jill, if you could get a granadilla plant. Oh, mine is out of control and I've got so many fruit. Like it's just constantly, and it grew in a year. I've clicked allow mic and cam and it's just stuck. You need to say add to stage, I think. I'm not like I know you guys think I'm a StreamYard expert, but I really am not. I can't remember what you did last time. So we call it passion fruit sometimes, and we call it granadilla other times. Passion fruit is more like, we call it passion fruit more when it's like the flavor. So like passion fruit juice, passion fruit ice cream, but we call it granadilla. So it probably is passion fruit there. Mint does take over absolutely everything. But it's a beautiful tree. The granadilla is a beautiful tree. Beautiful, beautiful. Also, Evie, I don't know what you did last time, but you did something right then. I just feel like we're not actually going to watch. There goes my phone. I feel like we're not actually going to watch court today, and we just need to like be okay with it. Because my brain is not holding down that thought. Oh, work laptop. We're right by the sea, so Steve, it was all planned. Have you guys noticed how I get lower and lower and lower? We also actually have low humidity here. So we mostly have fynbos, which is literally translated to fine bush. If you've seen protea flowers, that's kind of, yeah, that's the vibe. Evie, the other option is to do Google Meet, and I share my Google Meet screen. That could work. Oopsie. I need to have like the other chair here for Friday so I can be in a comfy chair on a Friday. Okay, guys, I'm going to push play on Judge.
Is in for Miss Kim.
I am, Your Honor, Lou Masco here on behalf of defendant. I also have a student attorney with me who's going to be doing the hearing, with your permission, Your Honor.
Who is this?
Sorry, I can't hear anything. Can you guys hear me?
Oh, yes, we can hear you. Can you hear us?
Yeah,
Yes,
sorry, just
I
cutting
can.
up a little bit. Hi, Your Honor, my name is Fatima Atwa. I'm asking for permission to practice under my supervising attorney, Lou Masco, under Michigan Rule 8.120.
Okay, I'll let her practice. Permission to practice is granted.
Thank you, Your
Great.
Honor.
You're a student where?
I'm at Northern Illinois University. I'm going into my third year.
Oh, that they're not Salukis.
Huskies.
Huskies, yes.
Yes.
Okay. I always watch them play football. I don't watch anything else about them. All
Yeah,
right,
they're
what brings you this way?
I'm actually from Michigan. I just went out of state for law school, ended up in NIU.
Oh, so you didn't like any of our law schools?
I just wanted to see what was out there, get a taste for a
Okay,
different state.
I did the same thing. I just
Oh,
went
no,
east.
wait.
I went east, so I get it. I understand. What part of Michigan are you from?
Dearborn Heights.
Okay, fantastic.
Steve, we did it, but we did it without music because the music was annoying me. There is a book called My Big Shouting Day. You guys need to see it. You need to read it. It's great for all ages. That is me today. Basically, the synopsis is everything is too whatever. So her tea is too hot, her shoes are too tight, her this is too this is too that. That's me. Lights are too bright, sound is too loud, brain's too tired. It's a big moaning, big shouting day.
Esther. Okay, so I'll let her practice. She's a Michiganian. All right. All right, what are we doing on this case?
Your Honor, I have sorry.
Sorry, go ahead.
Oh, I was just gonna say, I have a balance including court costs of $1,103.31.
$1,103
Yes.
and 31 cents. Okay. All right. And where are we proceeding on this then, counsel? That was to you.
We're asking for time to file for an answer and would like to reserve the right to request discovery. Our client is on subsidized housing and is currently paying $0 for her rent.
Okay, so she's currently at $0.
Yes.
All right. How much time did you need to file an answer?
We would like 2 weeks due to the holiday.
Oh, come on. You're a student. You don't need 2 weeks. You'll work on it all the time. You can do it in a week. Okay, fine. All right. I'll give you just short of that only because of the timing of the court. So we need an answer by the 10th.
Sounds good.
Okay. Anything
Send you
else
the
other
wrong
than a
thing.
new date? Would it make sense to come back on the 12th or the 19th?
I think we could do the 12th, Your Honor.
The 12th?
And then if there's any discovery, maybe we can get, if you want to informally request some discovery, and then we can see what we can provide. And then if we need to talk to the judge more about it, then we can do so at that time.
Okay.
The only one thing I would add, Your Honor, is that there are some.
Oh, I knew it. I knew Masco would not let her just do it herself. She was gonna butt in. She was going, just go ahead.
It's
Go
harder
ahead,
to this.
Masco.
I can let Ms. Woodwood contribute, but I just want to just point out, Your Honor, for the record, that there are some pretty severe repair issues, and the plaintiffs have been notified by the defendant, but we can communicate directly with the counsel about those issues, and hopefully we can get some of them addressed before the next hearing.
I'm seeing some damages charges on the ledger, so I think probably we're gonna need to figure out
what which go where.
exactly.
And see, I had faith in you. You could have said that same thing to me. But every time Masco shows up, she can't be quiet. She shows up with a student. She won't let the student just play in the sandbox by themselves. The whole thing. Anyway.
I appreciate Masco. Thank you.
Oh, no. You didn't have to say that. She's not going to do anything to you. Fine.
Ben will be here in the future, so everyone will be in better shape.
Oh, no. Okay, that's going to be a problem. Probably should have just been quiet. July 12th, 2024 at 3 p.m. All right. Thank you, folks. A pleasure meeting you.
Pleasure meeting you too, Your Honor. Thank you.
He is Brandy.
Court calls the case. Strong Future Homes versus Ashley Womack. Hello.
Yeah, I got it.
Hello.
Hi.
What's your name?
Ashley Bowman.
All right. Is there something you're trying to hand?
Yeah.
Okay, hand it to my bailiff. What is it?
Well, I couldn't make my payment today. The reason being is because my job sort of messed up my paycheck. They sent me to a few different stores. I know I was supposed to pay the full amount today, but they said it takes about a week for that to kick in. If that doesn't kick in, then my check comes in a week after that. So I would be able to pay it. It's just I need a little bit of time.
Okay, so I guess this is a TSFR Care Fund application.
Yes, I have one in. I just wanted to let you see what it was. That's
okay, so
I am
you were
here.
going to make that application to pay this? Is that?
I already did. I put it in today because I was originally supposed to pay the full amount today.
Yes.
But my job, they sent me to a whole bunch of different stores because I'm a manager for Wendy's. So they had me going to like 5 different stores and I'm missing a whole check. So they told me that they're going to try to cut me a check. If not, it's going to be on my next payday. So that's why they had me put this in. So she was going to try to get this put in before my next paycheck.
Okay, I see. All right.
And my next paycheck is on the 8th.
I'm sorry. Would you mind if I just looked at it really?
Yeah, I'm sorry. I should let you see it also.
It's actually through our company.
But I have a blank one, but that you've already
I
submitted
turned it in.
that.
It's already submitted.
Okay, so how much is your monthly rent?
I think at the moment it's like $52. And what?
Hold on. Is that right? So you're subsidized?
Yes.
Okay.
And I was in jobs. That's where I got.
Pardon?
I went from Taco Bell to Wendy's, so it kind of got all messed up.
From Taco Bell to Wendy's?
Yeah.
Sounds like a Friday night for me. Okay, so. I don't even know why I said that.
It looks like rent for June was $25.
Yeah, so it's like 25.
$25?
But before then it was 50.
Okay. All right, so I was at 516.88 last time we were here, I think. Okay. Okay, so ma'am, how long? So you're either gonna get a check or that's gonna come through, right? Okay, so how long will that take? Did they tell
Said
you?
it takes about 7 days to see if this will be approved or not, but then I get paid like a week after that, and I could just pay that through that, so.
Okay, so when do you get paid now? The 8th?
Yes.
Okay, so let me do this. Let me adjourn it to the 12th. Because what's gonna happen is $25 will kick in, but we won't be too bad off. And maybe that'll come through and everything, okay? July 12th, 2024 at 3 p.m. Okay, thank you, ma'am. Court calls the case of Strong Future Homes versus Alana Lindsay.
Filling in for plaintiff. I don't have the Senate check.
Alana Lindsay? No response. Would you like to take a default?
Yes, please, Your Honor.
Raise your right hand to be sworn. Do you solemnly swear or affirm testimony you're about to give will be the truth, whole truth, and nothing but the truth, so help you God?
I do.
Go ahead.
This is the case for non-payment of rent. I have rent to retain possession of $830, court costs of $176, for a total of $1,006. Plaintiff is requesting a default judgment for possession only with a written.
Judgment to the plaintiff. That is by default for possession. Redemption amount in the amount requested. Writ issued 10 days. Evergreen Apartments versus Lavinia Kendricks Haynes.
Jillian Ingham.
Okay, come on now. Better judgment. Zero judgment. I didn't solve that. Sorry. Your name?
Lavinia Kendricks Haynes.
All right, very good. Okay, and where are we on this case?
Your Honor, I have a balance, including court costs, of $3,216.69. I have a note that there was to be a payment of $300 and then a $700 payment today, so I just.
I did the 300 already.
Okay, was that to the court? Or
Yeah, it
was
was
that
to
to
the.
That was on the 14th.
Yes.
And then she was gonna pay 700. You're gonna pay 700 today.
I can't pay the 700 a day, but I can do 3 because the doctor put me like on restrictions and I haven't been getting my full hours at work. But next week I go back full time, so I do be doing 8 hours a day.
Okay.
And also too, I have extra income that I will be receiving every month too.
Okay, but what's your monthly rent?
$12.69. Isn't that correct?
It's either 12.59 or
12.69.
12.39, something like that.
12.69, I think.
Yes, that is correct. $12.69.
Okay, so the balance is around $3,200. So.
Not including the amount that's in escrow.
And that, right, 32, that's 600.
I get 1,000 and something on the 3rd of the month, and then I get paid again on the 14th.
On a Sunday?
On the 3rd of the month. It's funny coming from.
No, I know that, but you said you get paid
I get paid again in 2 weeks, is basically what I'm saying.
from,
My job.
no, okay. But the 2 weeks from what date?
2 weeks from today.
So the 12th.
Yeah.
Actually. You say you're gonna have 1,000 on the 3rd?
That money is coming directly from the government because my husband passed away, and those are benefits coming from him.
Okay, and is that a benefit that just started up?
Yes.
Okay, so you just lost your husband?
Well, he been passed away, but because I was working and I didn't apply for it when I should have, I wasn't getting it.
Gotcha. Let me ask you this.
Mhm.
On the 12th, when that next check, how much do you get? How much?
I should have, I would say a 2 weeks paycheck.
Okay. So what would that be?
If I put in, if 1 week I work 4 days, 1 week I work 6 days. Okay, so I just go back to work next week full time because the doctor put me on restriction. He would not let me work the full 8 hours because he didn't want me to have to go back through the process again, having to get better all over again. So,
Gotcha.
So I should have at least, if I go back to work on Monday, full time, I go back and get my 8 hours a day instead of working part time. I'll be doing full time. So I should have over $1,000.
Okay, but
if I work the whole, what do you?
Stop.
I'm trying to.
I got you. I understand you're trying to figure it out. But what I want to know is if I adjourn this out and I'm gonna, now the check that you get, the 1,000, that comes on the 3rd.
Right.
Okay. And then on the 12th, you're gonna get another check. Do you get it on the 12th?
I get paid from work on the 12th.
Okay.
I will get a check from him every month.
I got that. But what I'm trying to figure out is, when do you get paid on the 12th? Do you get paid on the Thursday before, or you get paid
on that Friday?
Okay, and when do you usually get paid?
I get paid every 2 weeks. I'm trying to.
No, it's okay. What time of day do you get paid on the?
I get paid that Thursday night.
Okay, that's what I was saying.
Yeah, Thursday night. It goes direct deposit into my account.
Okay, so it's available to you first thing in the morning on the Friday, right? Okay.
Right.
And how much do you think you'll have to pay?
That check should be
I shouldn't have.
7-day check.
Okay.
That check should be 7 days.
Okay, I hear you. How much money do you think you can have that day?
That check should probably be around 900. That check, because they're gonna do deductions.
Yes.
Things are coming out.
Like FICA takes stuff out.
Mhm.
Okay. So let's do this. I've got 300. I have a total of 600 in escrow
Now.
now.
And I want to pay 300 today.
You're going to pay 300 in escrow today.
Mhm.
So that
Oh.
was 900 escrow.
Yes, she would have 900 in escrow. You can pay 1,000 on, and I'm going to put it by July 5th. Okay, but I want you to pay that 1,000 directly to the landlord.
Okay.
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 Put the 300 in escrow, pay the 1,000 to the landlord.
Okay.
Then, it's going to give me 1,900, but then she's going to be up at
Oopsie.
about 30, 4,400. Coming up.
Oh my gosh, I'm so comfortable.
Okay, so here's what
I did it.
I want you to do.
Yay!
Okay, because you're not quite sure how much you're going to have.
Right.
Okay, but
Because I've been working.
no, I get it. I get it.
Okay, I don't think we have the patience to hear the story out. Evie wants to show her figs right now. Oh my gosh, how have you kept that alive? Oh, I hate fiddly figs because they just die on me.
Look at my yucca.
And then a yucca.
Mm. Oh, I feel like such a noob. There's my big leaves.
Your volume is super soft. But is it me? I can't tell.
Wait, it might be me because my husband is also talking on Discord, so he's loud.
So basically, I've adjusted my setup that I have Vaughn's chair because Vaughn's got a standing desk. And then I've got my chair across from me with a cushion on. And so I'm basically in like poor man's lazy man. Like a lazy man.
There's my plant. There is my plant too. Yeah.
I did
I
something
did
and I
okay.
wasn't supposed to do it. I can't do fiddle leaf pigs. I can't. I want to so badly. They're so beautiful. Also,
It used to
apparently you
have
should clean
leaves.
it with like. Apparently you should clean it with like a cotton thing and milk on the leaves.
Milk?
Yeah, stops it from getting dusty.
Oh,
I do
I
it to
did
my
actually dust
monsteras.
it earlier. I had to dust it.
Yeah,
'cause
because you get leaf shine stuff, but like, why am I buying that in a can when you can just use milk? Oh my gosh, Mel, I named a plant when I came out of the clinic and I was like freshly sober. I got a plant and I named it Vicky so that I could like take care of myself, and it died. The therapist was like, let's not do that again. It's not a good experiment.
Am I still quiet?
A little. I don't know. I guess it depends how my volume is in comparison to yours. I can't see where
mean-
my volume thing is right now.
You feel quiet to me.
Oh, am I quiet?
Yeah, but it could just be me. Because I made
Let's
a
say
very-
automatically adjust mic volume. That should be good.
Okay, I've clicked that.
Then it should technically. I had that thing that RA said I should download, but like it's takes up so much space, and I'm trying to get all of Judge Simpson's things as they happen. So I don't have the space. I hear her more than enough. Oh my gosh. But wait, also I just realized I was joking about making you both mods and now you are both mods. So you actually can't time each other out, right?
I don't know. Oh, I can't do it on that. I can't do it through StreamYard.
I also don't think I have the mod thing on, so I can't I don't think I know when people get timed out.
I can only block him.
I can be a super mod. What is a super
I
mod?
don't think you qualify.
I think he does because I gave him permissions.
Can you revoke them?
I've already revoked one today. Let's not let YouTube think that I'm like hacked or something because I had to add all my ID stuff and revoke someone. So they're going to be like, what? Like, what is happening on this channel?
Licking eyeballs.
Oh my gosh. Is Brandy still here? I think Brandy's gone.
Oh no. I thought I had one of the. I do. This is a part of the this is a foot bit, toe bit. I hope that doesn't cancel your YouTube.
No, they don't. How's this? Like, honestly, guys, if you want a fun read, go and look at the guidelines and how specific they are. You you can't cut meat without it being flagged. You can't do certain kinds of ASMR. It's like oddly specific. Steve. Oh my gosh. That's funny.
It's bigger than the emoji.
It's bigger than Adam's.
Mhm.
Oh, funny.
Adam's gonna get
Where am
our
I? I
rage
keep losing
demonetized
track.
now.
What?
He cut a watermelon up, didn't
And that probably counts as ASMR. No, that's not a fig, that's a bone. A fig is, wait, can I even type at this angle?
That's a fiddle fig. Big old leaf.
That's a fig.
That's a frig. A frig fruit.
They are super yummy. Seasonal though. That is a bad fig. They should be like red. That looks pretty dirty.
You're a rotten fruit, Adam.
You can also have fig. My gran used to make fig jam. That was nice.
I've had that.
Oh,
Did you hear
listen,
my
you
goat?
need to explain the bone situation. Not everyone was here for that. Also, your dog is setting off Mel's dogs.
I'm sorry.
Oh, sorry. I clicked the wrong
I
one.
can hear him. He's gone. 1 minute. Let me just shush him. Be quiet. Did I
Now you
not
have to
make
tell the bone story.
I went on a walk in the woods and found a deer leg just on in the woods. So I picked it up, took it home, let it decompose, and kept the leg.
How do you let it? Do I even want to know this?
Probably not.
Because I have questions, but I don't think I want to know the answers. Also, the reason I said
I'll
that
happily answer them.
I don't know if I want to know because like I'm verging on vegetarian very often. So I probably shouldn't know. But the reason I said Brandy would like it is because she does cadaver removal. That's her job.
Holy shit. Sugar, honey, iced tea.
Oh, it doesn't matter. There's also a content warning at the bottom. And Judge Fleischer dropped an F-bomb, so.
I carried it to my friend's car for about half an hour, hid it in my bag so they didn't know that I had it.
I feel like the story started as like something super chilled, like, oh yeah, I have a deer's leg, it's fine. And then the more it progresses, the more it's like, are you okay?
Yeah. It. Yeah. I fed a lot of flies. That's what I'm saying. A lot of maggots got there.
So you did it the natural way. Let nature take care of itself.
I put it in my garden and then waited a year and was like, there you go. That's right.
You remembered it was there though? Oh my god. She's not wrong. Because like
yeah, but I
mean,
didn't kill it.
Yeah.
I got a little 101 Dalmatian.
Oh right. You need to do it like
one.
Yeah, that's better. I mean, like, I don't have a single tattoo. How I've gotten this far, I don't know. I honestly don't, but I'm glad because there was a long period of time where I wanted live, love, laugh tattooed. I wanted to write live. Oh my God. I wanted to write live. I wanted my mum to write love, and I wanted my ex-best friend to write laugh. We're not friends anymore. And also love, love, laugh. Oh, it would have been so bad. Now I just want a little bee. That's all I want.
Get a bee.
Because
got a
bees are
broom.
so cool. Like, I think bees are my current hyper focus. What is that one?
A broomstick. But not for Harry Potter.
Oh, cool. I've never read or watched Harry Potter. I'm so
Oh,
glad I
wow.
said that on stream.
You've ne-
Yeah.
Well,
So when I was a kid, I went to a Christian school and they believed that Harry Potter was evil. And also their Pokemon was also evil, and there was black dust in the middle of the cards, which was like very satanic. So yeah, we also weren't allowed any kinds of like symbols or,
that would have been do you still stand by that?
I would probably read or watch Harry Potter if I had the attention span, but I tried, like I love reading, but it's very kiddie-ish, and obviously it was written for kids, like can't blame her. But I just haven't been able to see it through. And also I read a lot of like thriller, real life stuff. So Harry Potter is difficult because it's not real life. And I also discovered I have like a degree of aphantasia, which is when you can't visualize things. So if you say like, imagine you're standing on a mountain, it's probably an ADHD thing, to be honest, because we're so literal in so many ways. Like, imagine you're standing on a mountain. Okay, but I'm not. I'm sitting in a chair. What are you saying?
True.
Wait, I want to go back up.
Look at Steve's comment.
A murder hornet.
No, look at his recent one.
What? I went to a Catholic school in second grade, got stabbed during recess. Well, yeah, the Christian high schools is always where everyone got their drugs. They knew the difference in fact and fiction, so it was good. Yeah, apparently not. I know, right? I'm so glad I didn't do it. So glad I didn't do it. Mel, I can't even pull that up because that word will get picked up. Wild. No, it's okay. It's okay to have it in the chat. I just don't want to put it on the screen because if somebody is, because they're probably going to like sit and manually review every video. And so they're going to be looking for like controversial content.
Will they not put up live chat?
I doubt it. They'll probably, to a degree, use like the AI generated summary and see if there's like controversial issues or like something like that. But it's really got to be, it's got to be quite extreme. That's why I'm not that bothered by what people say in chat, because like they understand. I marked that it's not for kids. So if you mark it's for kids, then thanks, Adam. That's kind. Listen, she got the infinity tattoo. I didn't actually commit to anything.
That's true. Yeah.
And I'm all about grandma chic. So if your mom's a grandma. Cottage core is what the youths are calling it. Oh, Adam got a smack.
Also, Mel, just on yours, I don't think any nun should do that, no matter what the child did.
No.
No.
They shouldn't be allowed to. Your chair looks hella comfy in comparison to mine. Although they all lean back so far. like what we really need in the world, let's take this to Parliament. What
That
we
didn't
need in the
happen.
world is keyboard trays or like a keyboard thing that goes on the chair that is comfortable.
Yep.
Because they do exist, but they're very hard to find. And that's why we're all struggling ergonomically. That's why we all have funny wrists and thumbs. Yeah. Adam's getting kisses. A smack and a kiss. Did you guys do first of the month there's a pinch and a punch, and then it was like a slap and a kick for being so quick? Oh, Steve, it's a bad time.
Yeah, but you said that a lot differently than I do, even though it's the same words. Pinch, punch, best of month, no returns. That's what we used to say. And then
No
the
returns.
slap kicks in so quick.
We say like the extended version, a pinch and a punch. Pinch and a punch
I'm a
for the first day of the month. Yeah, it's Adam, Steve. It's Adam. Tell your client you have an urgent call. I mean, I can totally like mod my own chat. Like I can remove people. I can remove messages. I see there was something that Adam retracted was the spelling of my name.
Because if he does it with
also,
a Y, you'll be
yeah, because it's supposed to be with an I. When I was the same school that was no Harry Potter, we used to do, you know, those things.
Mm-hmm.
So there was one of those where we would say we'd be wearing dresses and we'd lift our dresses and we'd say the girls go whoopsie, the boys go wow, and they banned it. And I was like, what the heck? Like that was just so fun. And then kind of realized now why.
We had something similar, but I can't remember what it was.
I'm also 5'2", Mel.
I'm 5'4".
That's quite tall.
It's not. You're just short.
But I'm like average height. Like whenever I'm in the UK, it's so nice because everyone isn't so massively tall. Like here, people are tall. Vaughn is 189 and he's not like super tall. He's like pretty normal height.
That's pretty tall though. How tall is that in foot?
Over 6 foot, I think.
Good Lord.
Can't maths. 1.89. Why do you do feet instead of meters?
We use both, but I only know my height in centimeters, so
He's
I
6
can't
foot
work it
2.
out. Oh, famous now.
So we're the same heights, basically. Come to his elbows. I think I'm like up to Vaughn's chest. So my problem is the top half of my body is tall. It's my legs that are dinky. Oh, sorry. You guys need to entertain yourself a second. I need to ask my sister to send me a link for the thing. We're staying in a hotel tomorrow and I need a link.
I swear in America they just want to use the opposite of what everywhere else uses in like metrics.
Yep.
It's really confusing, especially as everything is so Americanized, and then it's just like, but stop.
And everything I write, I have to write in the in both.
No use.
Yeah, so all of my writing, and in South Africa, it's really weird because we were obviously a British colony, so we used to do UK schooling, but then we have like heavy American influence because of movies and stuff. So like some stuff we write English US, some stuff we write English SA, and then I get confused between the two. But then also because I'm writing for a US audience, I have to write in English US, and then I have to convert everything. And like literally the only countries that's using that system. So if I'm writing about England and the US in the same thing, I have to have all of the measurements for both places.
I don't like that. You should stop.
And Americans measure everything in football fields.
Why?
I
Also,
don't
what's
know.
a
Guys,
block?
why do you measure in football fields?
I do want to know.
I'm gonna have to go give the cats food soon.
Do we have any updates on Karen Reed yet?
Aren't they going home for the day?
What's the time?
Do you know what? This is the point I've actually reached it. I actually don't think I care what happens with her. I don't think I do. I just want it to be over. I think like it's reached that point of like I'm apathetic. It's not that I like if they come back and she's guilty, we know it's a problem. They'll appeal it. Something's wrong. It's just more evidence that the jury system is wonky if they do.
Yeah.
So
in Scotland, they have a really good. They have 3 verdicts can come in.
oh yeah, the
It-
not proven thing.
Yeah, I love that
So clever.
because just because you're not guilty doesn't mean that you're innocent.
But you guys don't have juries much either anymore, right? It's mostly bench trials.
I don't know. Everything's so shut off in the UK.
I wish that we could watch the streams because like that did you follow that story with the teenagers where this guy and this girl lured a teenager into a park and they had like a murder list.
Yes.
That was
I think
such an
Channel 4
interesting
did a
one.
documentary on it.
Yeah. And they did a good job.
Yeah.
Like the reenactments and whatever.
Oh, Teresa was a juror in a murder trial.
Oh, that must be so. I don't want to say the rest of that sentence because it sounds like crime tourism.
That
But you know what I want to
actor being a
say?
juror would be
It would be
cool,
fun.
not
Yes. It used to happen all the time in the newsroom. Like, yes, there's a murder. And people are like, what? Sorry, I need a job. Like, we've got a job to do.
I'm not the weird one anymore.
Nope. The way you said that made me think of Charlie in the Chocolate Factory when he says, everything in this room is eatable, my dear children, but that's called cannibalism and is frowned upon in most societies.
I don't know
love
why,
that
but
movie.
I mean, that's a full sentence. I sound more British when I'm here than I do normally.
My cousin said the same. He's like, I didn't even realize that I sound so British.
I can
And I'm
hear
like,
myself going more British.
And I don't sound normal because I I lived in Zim and they speak like hot potato English. So everything is very spelt out, like very hot potato. And then here we say fish, myth, lark. Yes, I am. I love Charlie and the Chocolate Factory, but I love the one with Johnny Depp, especially the beginning when they're doing that show and then the faces are all burning off. And he's like, really dodgy in the middle there, but that ending was phenomenal. I
How
am
often do you watch it?
100% going to watch that movie tonight.
Is that the real reason you went to Scotland? Did you want to go to that one experience?
I didn't even know it was in Scotland, actually. Like, that would have been so cool, though.
I think it was in Edinburgh. I mean, it wouldn't have been cool because that would have been a waste of money.
Everything in Edinburgh is so expensive, even Primark. Teresa, I'm guessing you love it too. I absolutely love it. And one of my nephews is on the spectrum, and our humor is so similar. So watching that kind of thing together is the best because kids just like they just get the humor differently. I love it.
I love Grizzly True Crime.
Oh yeah, but I think she's Afrikaans, right? So her accent would be different to mine. Be more Dutch-like. Yeah, I definitely have to go back to Edinburgh. I have to. And Vaughan needs to see more. He didn't get to see much.
I went there when there was apparently Northern Lights, and it happened the night that we had an early night. So
You were there exactly because it was like 2 weeks before I was there. And when we were there, they were like, oh, there was just Northern Lights 2 weeks ago. And why?
Yeah. We found out in the morning and we were like, oh, okay, we slept through all of that. That's great.
To be fair,
Enjoy your
it
dinner.
apparently happened here too, and I couldn't wake myself up for it. So Mel, enjoy your dinner, and I'm sure they're gonna love the flowers.
Yes, I hope they enjoy them.
What was I looking for? I was looking for something.
For your sister?
I messaged
All
my
right.
sister. Yeah, I messaged my sister. She's on date night. So she can't help me right now anyway. Totally misspelled my idol's name. Anne Frank. Wait, I'm confused. What does Anne Frank have to... I've forgotten now. What does Anne Frank do with Edinburgh?
I'm well too.
I did see something about Anne Frank in Edinburgh. Isn't it in the Writers' Museum?
I need to Google it now.
Oh, Jill, I misread your message. I see you said I sound like her. It's probably because of our eyes, which I tried to fix because I dated a Brit and he used to tease the way I said I because I said it like bull, milk,
Hold on, what?
Yeah, that's how we say it here. So like big fig would be like big fig. That's how people think we sound Australian.
Why is that a bad thing?
I don't know. Can't say much when you're from right by Essex, can you? Not exactly. Not you.
Essex.
Him.
Right by.
Not exactly talking like Prince Andrew, are you? So leave my eyes alone. You too,
No,
Adam.
wants to talk about him. What?
Dateline. Oh, date night. My brain is so mushy. It actually cannot even read properly anymore. I think I need to call it
Okay.
I can put on Felicia while I get ready for bed, but I can't talk. And I'm not leaving
gonna
anyone
stay
else.
here.
I'm not leaving anyone else to end the stream. No, I'm joking. Adam
Yeah.
did a phenomenal job. He did better than I did when I forgot to end the stream just earlier.
I mean, I did have to tell him, so I'll take the credit.
Oh, that is funny. I didn't even realize. Let's see. I love that he chats though. Like, that's so fun. How does that? Oh, you can't see a stinking thing. Okay, share screen. Judge Fleischer. Let's do this because I'm going to listen to him while I get ready for bed anyway. Okay. Wait, there's something. There's exclamation marks. Oh, thanks, Jill.
Time to glue your doge.
Okay. If I don't come on to say goodnight, you know that it's just that I ended the stream because I got tired.
I'll see you later. Thanks for having me.
Thanks for coming on.
Sorry it took me about
It's
5
been
hours.
a very all over the show Friday night, but it's been fun.
ADHD.
Also, we're not ending the stream, by the way. I'm just moving over to this one. No, Steve, I'm not leaving. I'm not leaving you guys alone. I'll be watching chat. So try behave.
I'll be in chat. Bye.
Bye.
Morning.
Just give me a second to log on.
Okay. Let's go. Morning, Steve. Morning, Stephen.
Morning. Morning.
Brock. Top of the morning. You ready? All right, let's rock and roll.
Present on Mr. Ibarra this morning.
You said Ibarra?
Yes, Your Honor. Page 18, Your Honor.
Thanks. All right, do you mind bringing him up?
Yes, Your Honor, he's on his way.
All right, Mr. Ibarra.
Yes, sir.
Sir, you're charged with driving while intoxicated, second offense. This is a Class A misdemeanor. You're facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
On June 22nd, 2024, in Harris County, Texas, an officer observed defendant's vehicle slow to almost a stop before a main intersection with a green light. The vehicle then proceeded very slowly for several miles under the posted speed limit, which was 45 miles per hour. Additionally, the officers observed the defendant failing to maintain the vehicle safely between the lanes and at 2 different times nearly striking other vehicles in the lanes next to it and causing other vehicles to avoid collision by swerving away. Officers then initiated a traffic stop. The officer observed in plain view a clearly open Dos Equis bottle and the defendant having red glossy eyes, a strong odor of alcohol on the breath, and his speech being initially incoherent. While getting out of the vehicle, the defendant stumbled and could not maintain a steady posture. Officer advised the defendant that he believed he was intoxicated based off his observations, and the defendant nodded his head in agreement and stated he did in fact have a few drinks at a family gathering he was traveling from, but he could not recall how many drinks or what he drank. The defendant stated that because of his injuries to his body, he could not do physical tests, However, the defendant allowed the officer to conduct HDN test on his eyes, which was a 6 out of 6. The defendant was transported to Harris County Joint Processing Center, where he was read DIC 24 and declined to provide a breath or blood sample. A warrant was obtained and blood was drawn.
So he had alcohol in the car.
Yes, Your Honor.
You know that it's a minimum of 5 days in jail to any sentence that you do when there's an open container in the car, Mr. Ibarra.
Sir.
Do you have a Texas driver license, sir?
Yes, sir.
I'm gonna take away his privilege to drive.
The license is still valid at this time, Your Honor.
Yeah, but he's got alcohol in the car. That's a big no-no.
I understand, Your Honor. According to the information I was provided, the bottle was empty. The officer saying it's about a third full. I'm not sure. I mean, I'm not saying the officer is lying. I don't know this officer. It's not an officer I'm familiar with. I would at least like an opportunity, Your Honor, to at least see the video to see if this bottle actually had anything in it. Because according to him, as
taking
well as
away
the
your privilege
passenger.
to drive at this moment because you have it. If you can show me differently, come back to me, show me. But at this point, no driving, Mr. Ibarra. You have alcohol in the car. I'm finding probable cause in your case. I'm also ordering you now to obtain a handheld interlock device that you're going to take with you to prove to me that you're not consuming alcohol. You will be randomly tested. If you consume alcohol from this day forth, I'm going to put you in jail. You will not get any more PR bonds from us. Do you understand, sir?
Sir.
If you have a drug or alcohol problem, you better address it. Because if you don't, I'm going to do it for you. And I promise you, you're not going to like the way that I do it. Do you understand?
So, Your Honor, I do have a question. I believe the state shared some of the videos that they have with me today. If I were to look at those today and see that this bottle is empty,
Back to me next week, we can talk.
I want to make sure. Your
Happy to
Honor.
entertain you at any time. But for someone at this advanced age to have alcohol in the car, it's elementary that you know you're not supposed to have alcohol in the car, Mr. Ibarra. And now I'm going to take your privilege to drive away from you so that you appreciate the awesome power it is. Living in a city as big as Houston without the ability to drive blows. And I hope that you do appreciate it from now on. You will be signing an affidavit with me today, promising you that you're not going to drive. I don't care what's going on in your life. If you drive, I'll have a contempt hearing. You'll be facing an additional 6 months in jail and a $500 fine every time you drive because it's an offense in and of itself. Do you understand?
Yes, sir.
Does he already have an interlock, Ron?
They ordered him to get one. He actually had one appointment scheduled today. It looks like we're gonna have to cancel that and reschedule to get the actual portable, Your Honor.
So we're going to switch you for now to a portable device, Mr. Ibarra. I'm warning you, above all else, in the short life that we have, the worst possible thing you can do is get into a car and drive. Do you understand, sir? There's no quicker way that you can assure yourself a lengthy jail sentence. You have a lawyer. Listen to Brock. He will help you out. I will waive your appearance while you're in good standing with us. That means you don't have to come back to court and waste your time here, but you must stay in touch with Brock. He will tell you if and when you have to come back to court. If he tells me that you've gone MIA, that we can't get a hold of you, and if he can't get a hold of you, I will issue a warrant for your arrest. If you consume alcohol, drive, pick up a new case, or don't stay in contact with Brock, I will issue a warrant in those instances. Do you understand what's expected of you?
Yes, sir.
Okay, tell me, are you a United States citizen?
Yes, sir.
For now, I will have you come up here, swear to us that you're not going to drive. After that, I will get you to Victoria. We're going to have you sign a reset. And after that, you'll get with Trace for your bond conditions, and then you're free to go.
Yes, sir.
Okay,
And,
Brock.
Your Honor, I had
Just
one
come
more,
back and let me know.
Yes, Your Honor. I have one more, but it's off docket. What's a good time for me to come back and address it? I know you like to do your arrangements first.
What do you want to do?
I'm trying to see if we can remove random urinalysis as a condition. It's a DWI first, no criminal history. I'll give you the cause number.
Yeah, that's going to, I need a deeper dive on that.
Do
So
something
come
after.
back. Yeah, come back.
10:30 be okay? Give you
You
enough
think
time?
so? Okay. Yeah, what the boss says.
All right, thank you, Your Honor.
Mr. Lee, do you have an arraignment?
Well, it was an off docket matter.
It
Your
doesn't-
Honor.
It's okay. Is this, I mean, it's an arraignment. What, is this it?
No, it's not.
Those are just. Do I anticipate?
It was someone that you revoked the bond on a couple of days ago.
Yeah, and it was my fault. This,
But you fall on the sword, Mr. Lee?
no,
I
it
know you knew
really
better than
was
that.
me who who screwed up.
What's the cause number?
I don't have, give me a moment, let me look it up. It really was, I screwed up. We had it's 244554301.
Richmond?
Yes, sir. Her appearance was waived. I went and talked with, 2 days ago, I went and talked with Pavel and Logan and got an agreement for a TTI, and I didn't get a reset. That's all on me. It's an agreement. I must have an advanced stage of stupid.
Okay, don't worry about it. So was she here or not here?
Well,
She was
waived.
okay. Don't worry about it. We'll give you another reset. I'll reinstate it for you now.
Thank you, Judge.
Okay. So no. You can do it. I know. And I'll give you a heads up.
Okay.
But thank you for asking.
Thank you, Judge.
So do you have an agreement already?
It's a verbal agreement.
Okay.
I came in.
That's okay. So are you offering a PTI in this case?
Yes, sir.
Have you accepted it?
Yeah.
Okay.
I need to talk to my client, but I mean.
Yeah, and it's not too old. It's not, so I'm gonna reinstate it, Victoria, and it's not old, and he's got a PTI offer, so we'll just give you normal reset. It's just whatever, yeah, okay.
Page 1, Ackerman.
Your Honor, can you sign a stop for bars issue?
Yeah.
So I can give you a copy.
Page 1, Ackerman.
Good morning, Miss Ackerman. Ma'am, you're charged with prostitution. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you.
Saw on eros.com under the escort section when he observed an advertisement of a female in the Houston area. Detective Patterson called the phone number provided and made contact with the defendant. They met at a hotel room in Harris County, Texas, where she agreed to perform oral sex for $1,000. Once payment was made, the defendant was arrested.
Okay. Ms. Ackerman, I'm going to find that there's a probable cause to go forward with your case. Let me see. I'm ordering you as a condition of your bond not to participate in this activity again. If you violate this, I will put you in jail. You will not get any more PR bonds made. I will give you a lawyer so that you can speak to the lawyer today so we can figure out where we go from here. But this is not a good thing. Okay. So for now, I'm going to have you go to Victoria, sign a reset. After that, I'll have you take a seat in the jury box. Do not leave until you sign our bond conditions. Otherwise, I'll issue a warrant and then I'll have you talk to a lawyer here momentarily. Okay. That way to sign a reset and then to the jury box. So can you file no engaging in like?
Yes, sir.
Who's next?
They're on the hallway, so let's go. Page 2, Blake.
Take a seat for me in the jury box, sir. You're not allowed to leave. Good morning.
2, Bob, come on up. Page 3, Brown.
Shadrack Brown.
Give me 1 second, Your Honor. Mr. Brown, Your Honor.
Morning, sir.
Where did you think that you were coming today, Mr. Brown? Did you think that you were going to the beach?
No, sir.
In shorts?
Yes, sir.
You go to court in shorts?
No.
Would
it's
you
my
go
first
like
time.
to church?
No, sir.
Lack of disrespect. From now on, you come in long pants at the very minimum. Mr. Brown, you're charged with driving while intoxicated, second offense. You're facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. You cannot afford one. One will be appointed to you, sir.
On June 22nd, 2024, officers initiated a traffic stop after observing a driver run a red light at an intersection in Harris County, Texas, and activated emergency lights and equipment. The defendant did not initially stop and continued in a southern direction. While the driver continued to travel in a southern direction, the officer observed several bottles and cups thrown from the passenger side window. The defendant eventually stopped, and when he did, he opened the driver's side door, placed his hands in the air, and exited the vehicle. The defendant was detained and placed in handcuffs, and the front passenger was also detained and placed in handcuffs, but was released on the scene during the investigation. While speaking with the defendant, officers observed the defendant to appear disoriented and a strong odor of alcohol on the breath, slurred speech, red and watery bloodshot eyes. Defendant was asked to perform standard field sobriety tests, and the defendant refused all question and started to become belligerent by sitting on his knees and stomach with his hands behind his back, stating he was scared. DIC 24 was read. Upon completion, the defendant was asked to provide a breath sample and refused. He also refused to sign the DIC 24. Blood was drawn pursuant to a warrant and a prior DWI in Tallahassee, Florida.
How many other DWIs? Just one? What other
That's
kind
it.
of criminal history do we have?
That's his only prior DWI, but there's extensive out-of-state history.
It's a 19-page criminal history.
Mr. Brown, do you have a Texas driver license?
Yes, sir.
Run his license, please. Do you have liability insurance in your name?
Yes, sir.
Before we allow you to drive, I want you to prove to me that you have insurance in your name. As it stands now, this is a second offense, so I'm ordering you not to drive any vehicle that's not equipped with an ignition interlock. If you do not have license, then I'm ordering you not to drive, and I will give you a portable handheld device that you will take with you everywhere you go to prove to us that you're not consuming alcohol.
Sir.
I'm going to test you for dope, alcohol, and everything. If you have a drug or alcohol problem, we have a place for people who cannot help themselves. So no dope, no alcohol. If you cannot control yourself, then we have places for you.
Sir.
I don't want to have to do it. Don't force my hand.
Sir.
Do you understand?
Yes, sir.
I'm going to do everything in my power to protect Harris County. If that means putting you in there at a $100,000 bond, I'll do it in a heartbeat.
Sir. Is eligible.
Okay. So as it stands, no alcohol, drugs, random urinalysis, guardian interlock. I see that you do have a lawyer. I will waive your appearance because you have a lawyer, but you must stay in touch with Mr. Fleming and he will tell you if and when you have to come back to court. Mr. Fleming tells me that you're playing games. I will issue a warrant for your arrest.
Sir.
For now, I'm gonna have you go to Victoria, sign a reset. After that, I'll get you to Tracy for your bond conditions, and then we'll have you take a seat in the back while we wait for your lawyer to arrive. For now, I want proof before you leave today that you have insurance in your name.
Sir.
Okay?
Yes,
If
sir.
you do, then we'll allow you to drive, but you must have an interlock on your car.
Sir.
Please.
Right this way. All right, Judge, page 4, Garcia, come on up. Which one?
Oh.
Go ahead and see.
Matos is the last name, right?
Yes, sir.
Um, 10,000. It doesn't even matter because we didn't have PR bond anyways. But
Yes, sir.
So Eduardo Garcia.
Sir.
Mr. Garcia, you're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present during questions and interviews. If you cannot afford one will be appointed to you, sir.
On June 21st, 2024, officers conducted a traffic stop for passing the patrol car at a high rate of speed, which was 81 miles per hour in a 65 mile per hour zone. The driver was ID'd by his Texas driver's license, and he had bloodshot eyes, droopy eyelids, slurred speech, a strong odor of alcohol in the breath, and he admitted to drinking a bucket of beer. HGN was 6 of 6, walk and turn was 5 of 8, and the one leg stand was 3 out of 4. DIC was read, breath was consented to, and it was 0.101 and a 0.110.
Mr. Garcia, I'm going to find that there's probable cause to go forward. I'm ordering you as a condition of your bond not to consume alcohol, illegal drugs, or unprescribed controlled medication. Do you have a valid Texas driver license, sir? Do you have a valid liability insurance, sir?
I don't have a vehicle right now, so no.
Then you're not allowed to drive until you have insurance. I am making that a condition of your bond that you're not to drive. Do you understand? If you want to drive, come back to us, show me that you have insurance, and then we will approve you to drive. But until that point, do not drive. We're going to reset your case to give you time to hire a lawyer. I'm going to have you come up here, swear to us that you're not going to drive. After that, I'll get you to Victoria. We're going to have you sign a reset. If you like your license, get on it quick. Don't sit and wait a month, 2 months to hire a lawyer, because there are consequences with your license. So get on it quick.
Yes, I'll get on it.
All right. All right, come on up here. We'll have you swear to this, and then we'll have you go to Victoria next.
All right, case Ben, Hope, come on up.
Who's it? Well, what's the name?
Hope.
Hope. Already on the piece.
If we were to.
Next judge is page 11, Toledo.
Paul Pulido.
No, Raul Pulido.
Sorry?
Raul Pulido.
Oh, Raul. I thought it said Paul. Okay,
No,
Raul, I'm sorry. I'm sorry, sir. So you're charged with assault of a family member. You're facing up to a year in jail and/or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present during any questions and interviews of the state of Texas. If you cannot afford a lawyer will represent you, sir.
On June 20th, 2024, officers were dispatched to a person down call. They spoke with a complaining witness, the defendant's mother, who stated she and defendant got into an argument about him not helping around the house and not working. The defendant pushed the complaining witness with her hand against the wall, which caused her to hit her arm. She reported that she felt pain.
Is that it?
Yes, Your Honor.
Got it.
Yeah.
All right. Mr. Pulido, how old are you, sir?
18.
Did you graduate from high school?
Yes.
What are you doing with your life now?
Right now I'm looking for jobs, but at the moment I'm still looking for a place to stay at.
So, are you on the street?
For like 2 days, and that's it.
You had a place to stay, and now you're on the street. Have you learned anything?
Yes.
Be careful what you do. Be careful what you say. Otherwise, you'll end up on the street. You'll end up doing things just to survive that you would never think that you would do. You had a place to stay with mom. Now you ain't got none. So, have you guys had the opportunity to speak to mom to find out what she wants? Does she want him home? No?
She's okay with contact. Judge.
She's okay with content.
She's okay with contact.
I'm ordering you as a condition of your bond not to have any threatening or harassing contact with your mom. I'm also ordering you now as a condition to get a job. I'm telling you, if you want to go back home, the best thing you could possibly do is get a job, show up with some money, and I bet you'll have her on her twinkle toes. I don't know. Let's do this. I'm going to give you a lawyer today. I want you to explain the situation to the lawyer so we can figure out what we're going to do. I don't want you on the street. That's not a good thing.
I was gonna ask where I can get permission to leave the county, because one of my friends is letting me move in with them.
Let's do, I'm going to give you a lawyer today. Let's figure out your situation. I'd like you to talk to the lawyer. So if your mom lets you back, you wouldn't want to go back with mom? Or would you want to?
I just want to move in with my friend.
Where is it?
In Dallas, in a place called Arlington.
No, I'm not letting you go to Dallas. You have an open assault case. No. The problem is I can't see what you're doing in Dallas. I have no idea who you're hanging out with, what kind of trouble you're going to get into. It's the wrong thing. No, I'm keeping you close to me so I know that you're now going to be on the straight and narrow. Who else is in your life besides mom? Anyone else? Okay, so that's me now. Do you understand?
Yes, sir.
For now, I'm going to give you an application. Stephen is going to give you one to fill out for an appointed lawyer. I'm going to have you go to Victoria, sign a reset. After that, I'm going to have you take your seat in the jury box. Do not leave until we excuse you because you need to sign bond conditions. We need to figure out what we're going to do with your housing. All right? Come on.
Page 14, Stefan Veda, Garza, come on up.
Do you mind filing to the no threatening, harassing, no weapons? And then we'll go forward after that and figure out what we're going to do. Vic, who's this?
Stefan Veda, page 14.
You really think that we're going to give you PR bond after PR bond after PR bond after PR bond, Mr. Sepulveda? You got me bent if you think that we're going to keep doing this and play this game with you. No, sir. Your PR bond is revoked. You can't get that many. I'll appoint you a lawyer today. We'll figure out what's going to happen, sir, but men goes with you.
Page 15, Smith, come on up.
Taylor Smith. Ms. Smith, you're charged with assault of a family member. You're facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you.
On June 21st, 2024, officers were dispatched to an assault family call and spoke with the complaining witness, the defendant's mother. The complaining witness said that she was arguing with her son and the defendant came outside and hit her in the stomach with a rock.
Hit her in the stomach with a rock.
The complaining witness advised that she felt pain.
Ms. Smith, I'm going to find that there's probable cause to go forward with your case. How old are you, ma'am?
17.
You're 17. What do you do in life now? Do we know what mom wants, guys? Does mom want her back home?
She doesn't want a protective order, so she wants to go back.
If I drug test you now, what's gonna show up? Let's send her for a drug test right now. I'm sending you for a drug test, and then you must report back here to court. If you do not come back to court, I will issue a bond, and I'm gonna put you in custody just like I did the other person. I don't wanna have to do that, so come back to me as soon as you take a drug test, and then I'm gonna appoint your lawyer today. We're gonna figure out where we go from here. But you're in high school, no dope. Do you understand? No, I don't want to talk about the case yet. You have the right to remain silent. I have a bunch of DAs here. Anything you say, they're gonna sit there, type it to try to use it against you. I just want to know what, if anything's gonna show up on a drug test, and we'll go from there. All right? For now, I'm gonna have you sign a reset, and then I'm gonna have you get with Tracy, and then we'll see you back here in 10 minutes. Please.
All right.
Hold on, Miss Smith, is your mom here? Come up, ma'am. Hi. Hi. So who are you in relation to Miss Smith?
I'm her biological grandmother. I've raised her from a baby.
Does she stay with you now?
Yes, she lives with me.
Okay, so let's do this. I want to send her for a drug test. I want to know what, if anything, is in the system. I'm gonna have her come back within the next 15 minutes. We'll get the test and then we'll go from there. I'm gonna appoint her a lawyer, and then we need to figure out what's going on with her so that she doesn't get into further trouble. Sure.
The day that happened.
I don't want to talk about the case because I've got a bunch of DAs here. I know that you want to tell your side. I'm going to give you a lawyer. You can you tell what you want to tell me, to the lawyer, and then we can figure out where we go. But everybody's here is going to say it. And if it's something that hurts her where you think it's going to help,
But it may not. I
right.
understand.
So just hang tight, give us like 30 minutes and then we'll, yeah, okay. Thank you for coming then.
Thank you.
Okay.
Yeah.
Page 15, Solano, come on up.
Norma Solano.
Yes, sir.
Ma'am, you're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you.
On June 2nd, 2024, in Harris County, Texas, officers responded to a 911 call in reference to a motor vehicle that was driving recklessly in a park. Officers observed the defendant in the driver's seat. Car was off, but was later turned on by the defendant. When speaking to the defendant, officers observed a strong odor of alcohol on the breath, and the defendant admitted to consuming 1 twisted tea and later said that it was actually 1.5 twisted teas. Officers conducted a standard field sobriety test. HGN was 3 of 6. Defendant also has eye problems. The walk and turn was a 3 out of 8, and the 1 leg stand was a 3 of 4. The defendant consented to breath, and BAC was a 0.128 and a 0.121.
You said someone saw her driving though? That the officer saw her driving? You have that person, you know who the person is, right?
Yes, we have that roll call.
Okay. Ms. Solano, I'm going to find that there's probable cause to go forward with the case. Tell me, ma'am, how old are you?
Oh, 24.
You're 24. Do you have a Texas driver license, ma'am? You are not allowed to drive. Do you understand? I am now making that a condition of your bond. The worst possible thing you can do in this life is get into a car and drive, because I will have a contempt hearing if you do. This is a document, an affidavit that you're going to sign with me today, promising me that you're not going to drive. I don't care if there's a burning building, Mother Teresa needs to go to church. Do not drive. You understand?
Yes, sir.
If you want to drive, go get a license and liability insurance, and then we can talk. But until that time, you do, you know where you're going to end up. Now, I am also ordering as a condition of your bond not to consume alcohol or illegal drugs. I'm going to randomly test you. If I find likewise that you're consuming alcohol or drugs, you will go to jail. You will not get any more PR bonds, man. What do you do? How much money do you make a month?
2,000 or 2,500.
Say that again?
2,500.
2,500? Do you have any children? Where do you live? Who do you live with?
Myself.
In an apartment or a house or what? Okay. Do you think you can afford a lawyer, man? Let's do this. I'll have you fill out an application now, Ms. Solano. I'm warning you, I don't want any issues. Don't consume alcohol. Do not drive. You understand? Stephen is going to give you an application. I will also have you fill out this affidavit and swear to it. After that, we'll get you to Victoria to sign a reset. And after that, we'll get you with Trace for your bond conditions. And after that, we'll have you take your seat in the jury box while we find you a lawyer. And we'll go from there. Okay? Please.
Page 6, Spanish speaker. Hernandez, come on up. Hernandez.
Are you Oscar Hernandez?
Yes, Oscar Hernandez. Yes.
Mr. Hernandez, you're charged with driving while intoxicated. It's elevated to a Class A misdemeanor because of the high blow. You were facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present if you cannot afford one. One will be appointed to you.
On June 22nd, 2024, officers observed a white Chevrolet traveling westbound in Harris County, Texas. Officers observed the passenger side door sliding open and the vehicle to be traveling at a high rate of speed. Officers then initiated a traffic stop. Upon approaching the vehicle, officers stated that he observed the defendant to have bloodshot eyes, slurred speech, and moderate odor of alcohol coming from his back. The defendant also had poor balance and continuously swayed back and forth in an attempt to keep his balance. The defendant stated that his last drink was at 23:30 hours and had standard field sobriety tests were conducted yielding a 6.6 HGN, 7 out of 8 for the walking turns, and was not able to perform the one leg stand due to the defendant stated that he could only count to the number 10. Defendant consented to a breath sample, BAC was a 0.189 and a 0.188.
Mr. Hernandez, find that there's probable cause to go forward with your case. Tell me, are you a United States citizen?
No.
What happens if you go to jail?
It's gonna be on my children.
Are you in this country with or without permission?
¿Está usted en este país con o sin permiso?
Yes.
Without.
What happens if you go to jail?
¿Qué pasa si usted se va a la cárcel? No lo escucho.
No, no tengo,
¿Perdón?
no tengo nada de eso, no sé.
Think.
I don't have anybody except my children. Piense.
What happens if you go to jail?
¿Qué pasa si usted va a la cárcel? I got deported.
Right.
Exacto.
That's what I'm trying to get you to understand. This is the only warning, Mr. Hernandez, that you will get from me. If you go to jail and immigration finds you because they sweep it on a daily basis, they will put a detainer on you. You will remain in custody for 6 to 9 months, waiting for immigration to do whatever they're going to do. If you do not want that to happen, do not violate the conditions I put on your bond now. I'm ordering you as a condition of your bond not to drive. You do not have a license. No driving. I am also ordering you not to consume alcohol or illegal drugs. I'm going to randomly test you. If I find that you consume even a drop of alcohol from whatever source, I will put you in jail. You will not get any more PR bonds. And if you are unlucky enough, you're going to be in jail for an extremely long time. You will be signing a promise with me today, Mr. Hernandez. This is an affidavit, a document that you will swear to that you're not to drive. I don't care what's going on in your life. You cannot justify driving for any reason. You understand me?
Okay.
We are going to reset your case to give you time to hire a lawyer. So I will have you come up here, swear to us that you're not going to drive. I will get you to Victoria where we will have you sign a reset. I'm not done with you. I will have you sign a reset with Victoria. After that, I will get you to Tracy for your bond conditions. Do not drive.
No puede manejar. Okay.
Okay. Hey, hold on, Victoria, I have an attorney here that has 2 arraignments, I think.
We have like 4 Spanish.
I think these are Spanish too.
Spanish.
I think, Mr. McGinley, do you have any Spanish arraignments?
Yes, Judge, I have one that's definitely not Miss Humphreys, and then Mr. Robles, I believe that might be.
Juan Robles.
Humphreys is not in arraignment. Robles is the bond violation.
Okay, you're gonna have to give me to do whatever they're going to do. Mr. Ray, I told
His mother's in court too, Judge, in case it matters if you want.
Sure.
I'm just trying to find the one that is the teenager. We can always watch the rest another day. And then I'm going to say goodnight. Was it this lady? This looks like her.
Yes, Ms. Smith, come up.
Sunday, Steve.
No more marijuana. Do you understand? You tested positive. I don't know if you knew that that was going to happen. I had a feeling, you know, when the cat's away, the mice will play, right? So I'm telling you now, I'm going to drug test you 31 days from today. And if you test positive again, that tells me that you've continued to smoke. Guess what's going to happen?
You're going to jail.
Right.
Yeah. As you should. I'm angry.
It's okay. It happens. You know, we're all young and did things that we shouldn't do at one point, but luckily you've not dug yourself into such a hole that you can't crawl out of it now. The problem is what you do now at 17 will affect you for the next 40 years of your life, and you don't get it. And that's okay. That's why we're here to show you what happens. Some people get it. Some people are eternal kids for life and end up with a number on their back forever. So we don't want that for you. We want you to be on the up and up. Have you seen how many lawyers there are here? That's the way to life. The way to life is money. When you have money, good things can happen. Lavish vacation, nice cars. When you don't, at the very minimum, graduate and go on, you'll end up with nothing. So tell me I want to give you my card. You have my number. If you ever need anything, you let me know. Just tell me what kind of conditions you would like on her and we'll do it. Curfew, no contact. If she's hanging out, we're back. Just,
Definitely a curfew. Because the type.
oh, I'm sorry. Is this gonna hurt?
And she hangs around that I really don't know nothing about.
Okay. So let's do this. I don't want to put everybody on the spot, but I'd like you to get with Mr. Sims.
Yes.
So you're not in school now, right?
No, summer, yes.
It's summer.
Vacation.
So what are you doing now?
At home, with me, because I'm on vacation, I teach, so. we're both
Great.
on vacation.
Thank you for being a teacher.
Yes, and so, I planned some vacations for me and her sister.
Okay.
Because I've raised her two siblings from babies, I reared them. And I thought maybe by me going back to college and getting my doctoral degree to show them they could do it too, I wouldn't be going through this.
We're all young and did things, and,
Yes.
and if we need to put her in lockup, we'll do it.
If
Don't
that,
violate these conditions.
yes, if she violates that, I'm in total agreement because this is her chance to get her life right. And yes, I will.
So what time do you want? Mr. Sims, you get that?
Time to,
As far as a curfew, you want 9 PM, 10 PM, 7, 7, 11, okay?
well, let's do 10:30. You know why? Because when I do,
You don't have to explain.
okay.
Just do
She
whatever you
do come
want.
back. Yeah, 10:30 is fine.
Smoking weed, because I'm telling you, it will stay in your system for 30 days. If you go out there today and smoke, I will know. And I promise you, it's not going to go well for you. I get the attitude you're giving me, and that's okay. You can hate me all you want. It's okay. I want you to do well. And the only way is to make sure that we are on top of it and make sure that you're doing what you're supposed to do. And when not, and when you hang with dogs, you're going to get fleas. As far as it is now, so no harassing or abusive contact with the complaining witness, no weapons, and no dope, no alcohol. And I will test you. And that's it. As long as you can stay clean, you and I will be best friends, Ms. Smith. Okay, so hang tight. We're gonna have her take a seat. I'm gonna get with Tracy for the bond conditions, and then we'll go from there. You have my card. You ever have an issue, first get a hold of Mr. Sims, and he'll get a hold of me, and then we'll go from there, okay?
I appreciate you. Thank you.
Yes, ma'am. Thank you for doing what you're doing. Hey, Trinidad.
Slate on the docket.
Yes.
Now it is.
Slate or Blake?
Blake, I'm sorry, Blake.
Who's standing for Ms. Smith, right? Random.
And curfew. She said curfew 10:30.
Just at 10:30 PM. 7, 6 AM.
Sure, whatever she wants. Yeah. Mr. Blake, come up.
Hey. He's a little.
That's okay. He's not doing what he's supposed to be doing though. You know why you're here, right?
Yes, sir.
Why you here?
Criminal trespass. His mother.
You have bond violations.
He's currently living in a group home, Your Honor, and he's back on his medication. So we're getting that taken care of right now. We got a hold of his caregiver, and that's who got him here, make sure that he was here today. The last time the caregiver got to the house late, he didn't get the information, that's why he wasn't present. But me and Gloria worked on getting the the caregiver the information, and that's why he's here this morning. So he's,
Ms. Garza, do me a favor, remind me of the facts of the case, what happened, because I don't remember Mr. Blake's case. If you can just give me a brief rendition, Blake.
Officers were dispatched for a disturbance call, and the CW is the defendant's mother. He would not leave the property, and the first time officers arrived, he had already left, and then he came back. Officers came back and arrested him for not leaving and making threats.
that's what he
So-
was living there.
Sorry,
Living there at the time. He had all his things there.
but she didn't want him there, right?
Apparently, whatever was going on at the time. But again, I believe it had something to do with his being unmedicated. We're taking care of that now with the group home. He's got a group home now. He's getting stabilized with his medication. So we're trying to get to a resolution.
I guess my question and my only concern is the complaining witness and whether he's tried to go back and harass her again.
Your Honor, I spoke with the complaining witness myself, and
And?
she stated that this issue was just due to him not being on medication and drugs. And that now that he's been on medication and been in the group home, that he's improved significantly and there hasn't been any more incidents. So
We move it in the right direction.
she did say that she wishes for a condition that would be to take medicine and no drugs.
That's something that we're gonna be struggling with for the remainder of this existence.
Yeah, we've done that, correct, Ms. Garza? Have we not put a condition that he's got to continue to take his medication? I would have to imagine that we did that as part of his condition.
Just they were asking if Mr. Raymond, will you allow him to do a payment plan?
Yeah.
Okay, thank you.
For sure.
I don't see that as a specific condition.
But we recognize that ourselves, Your Honor, that he needs to continue to be medicated. Correct.
So remember that, so he just got another PR bond because you were just released from custody, Mr. Blake. One of the conditions that the magistrate set was that you were not to have contact with Jeanette Wiltz. You understand? If you violate this, it's not going to go well for you. I'm now adding on an additional condition that you must take your prescribed medication. What are you taking?
Yes, sir, I have to.
What are you taking?
Oh, segments.
Yeah, that's
They
good.
put, they change it every month also.
They're trying to figure out, they're trying to get him, to an equal spot.
I'm already off there in regular shot and everything normal, difficult. I know it's difficult is one of them.
No, we don't have to tell, we don't have to tell.
So understand, you will not get another PR bond. Mr. Blake, you violate these conditions again. This is your first time. I'm not going to play this game again with you. I promise you that. I don't care if you have Jesus next to you with Trinidad. You understand?
Sure.
I know that Trinidad gets a little testy, but I'm not playing games with you.
Amen.
You must take your medication, no contact, unless we know she wants to have contact with you. Do you understand?
Sure.
Okay.
Thank you.
We'll give you
Appreciate
normal
it.
receipt. Thank you. Hey.
All right. Good night, guys. I don't know if I'll see you tomorrow. I might take the day to just, we're going out to a beautiful hotel, etc. So I might just be 100% in it. Evie, I just quit the game and open it again when the ads come up. Because I'm also not paying for things. Because when I paid for Candy Crush, then I started paying for Candy Crush all the time. And then I landed up having a Candy Crush budget. And that was a bad idea. All right. Good night. Thank you for hanging out. It's been fun. 4 hours. I think this is like a record stream. Besides last night, of course. Bye. Oh, ADHD podcast is Sunday. Bye.